Gotta be quiet. Hey guys, welcome back. Gonna do another live here today. Looking at day 4 of the Abigail Zwerner trial. I know that a verdict has already been reached. Just I think yesterday, maybe the day before. But we're gonna watch the last day, I believe, of the actual trial. And I think day 5 is verdict watch and maybe a little bit of closing or something, maybe some jury instructions or something. But we're gonna watch day 4 today, finish it up the trial, wrap it up, and find us out something new. So if you guys have any ideas about what you'd like to get into as far as trials, or maybe any court hearings that you're aware of that you'd like to watch and whatever, let me know. Send me an email. My email's in the description on my YouTube channel main page. So let me know. But otherwise, let's jump into it.
Court is now in session. Honorable Judge Hoffman presiding. As always, there'll be no talking while his honor is on the bench. Now you may be seated.
All right. Good morning. All right. Is the defense ready to call their first witness?
Yes, Your Honor. We have designated deposition testimony of Ms. Zwerner back in and filed with the court back in September. There was no objection or counter designation. I intended to play portions of the deposition testimony today, and plaintiff has indicated that they will object to that. In addition, we had planned to read certain requests for admission responses, and I understand there's an objection to that. I'm unsure of what that possibly could be since they have a binding legal effect.
All right. Mr. Benny-Azam.
Morning, Your Honor. The issue here is just a cumulative nature of testimony and admissions, and so to the extent that
Which one are you taking up first? I've heard two different.
my understanding is that the requests for admissions were going to be read. If the requests for admissions are read, consistent with what Ms. Douglas just stated to the court, then the deposition testimony becomes moot and cumulative, and therefore inadmissible under 2403, regardless of the procedural appropriateness of doing so. Also, the deposition testimony that's been designated, at least a portion of it, is cumulative to the testimony of Ms. Zwerner yesterday when she was on the witness stand. And so, in the same way that if the witness was on the stand for however long and we would object and say asked and answered cumulative, the same applies here in this context. And so, it might be helpful, Ms. Douglas and the defense counsel were able to provide me RFAs and the deposition transcript. I'm happy to proffer them to the court so that the court can compare them. In essence, we're not objecting to say you can't do either or both. We're saying pick one. If you're going to read the request for admissions, read the request for admissions, and then the deposition becomes duplicative. If you're going to read the deposition transcript, there's a portion of it that's repetitive as to what happened yesterday, but the rest of it, if it wasn't asked yesterday, is fine. But then you can't come back and read the request for admissions.
Okay. Are these agreed upon what you're planning on doing so that I can read these?
Yes, Your Honor.
Okay.
Again, we designated this testimony, and there was no objection until today.
All right, I'll take a look at that.
Hey, welcome in. Welcome in. Thanks for hanging out on this Saturday.
Responses flag, is that correct, Ms. Douglas?
Yes, Your Honor.
All right. And how did you propose to play the deposition?
Yes, Your Honor. Just play the clips of the deposition in our case.
All right. I'm going to overrule the objection. They're obviously taken at different times and done at different times, and I'm going to allow them to do both. All right. Any other objections take up outside the presence of the jury?
Apparently, there's an objection to our first witness, Dr. Lee Hagan. He was designated. There was no objection to his testimony in real time. Motions in limine came and went. There was no motion in limine made with respect to Dr. Hagan until today. Mr. Hogan will argue that. He argued all of the expert issues at the motion in limine hearing, so he will present argument on that with respect to Dr. Hagan.
Before we proceed with that, did we start a court or joint exhibit number or list yet? We were doing letters for the court, that's right. All right, so these two, just for the record, that were handed up, the request for admissions and deposition transcript would be? What's that? D and E. All right, D will be the request for admissions for the record. E will be the deposition transcript. Thank you very much. All right, so you are planning on calling Dr. Higgins live, is that correct?
Yes, Your Honor.
All right, and the objections.
Yes, Your Honor. This is in real time. This is when he's called, so there isn't any issue of waiver as seems to be implied by defense counsel. The issue here is quite a simple one, in my view, Your Honor, in terms of the precedent, which is that an expert cannot be called to testify as to the credibility or the weight of another expert. The expert under 702, 703 has to provide some opinion testimony that is scientific, technical, or otherwise, and that is helpful to the trier of fact in deciding a material issue in dispute. Dr. Hagan, a psychologist, has not been proffered or designated to address an issue in dispute amongst the parties. What he's been proffered to testify to is whether or not Dr. Watson, who is plaintiff's psychiatrist, credibly conducted an evaluation of Ms. Zwerner. And there's a case on point that I've provided to opposing counsel, and I have a copy for the court if it might be helpful. And this is the Brown versus Corbin case in 1992. May I approach, Your Honor?
And just to, as you said, that this was in real time, meaning that this was not subject to any of the pretrial motion filings.
Correct.
All right, Ms. Douglas, you agree? Okay.
Yeah, it was not subject to, really, this was sort of the first news we heard about this.
And I alerted opposing counsel of the objection last week. And I've highlighted a portion on page 5 of that opinion, Your Honor.
All right, so what was the testimony that was not permitted in this case?
The testimony in that case is that Mr. Tuning, who is a accident reconstructionist in the Richmond area, had been proffered to essentially discuss the principles or concepts of accident reconstruction. So here are the types of things that are reliable, here's the types of things that an accident reconstructionist ought to do, and then his opinion in that case was effectively, I can't come to an opinion because there isn't sufficient information for me as an accident reconstructionist to come to an opinion. And the court in that case said, both in that paragraph and above, that that in fact doesn't even qualify as a conclusion or an opinion. Saying that I didn't or I can't come to an opinion isn't itself an opinion. It's not an opinion of technical or scientific or any specialized fact. And so effectively what it was offered to do, as is argued by Corbin, which was the proponent of Mr. Tuning's testimony in that case, was to attack, as it says in that paragraph, Dickinson's credibility and the validity of Dixon's investigation, and therefore properly responded to Dixon's testimony. In other words, we think that Dixon, in this case, didn't conduct an appropriate investigation, and therefore we're going to offer Tuning to say what an appropriate investigation is, so that that can rebut or discredit the testimony of Dixon. It's exactly what it's being offered for in this case. The opinions, if we look at the actual report of Dr. Hagan,
Let me get to that. And then also let me find the designation. Now, was there anything in their designation of him that goes to this issue that you're concerned with?
The designation of Hagen is non-substantive in my view, Your Honor. It's kind of a 2 or 3 paragraph thing that just says he created a report, see the report.
All right, go ahead.
And so when we look at his report, there's a section 4 on his report. It's a 22-page report, and the section starts with a heading that says opinions and their bases.
What page number is that?
It says page 3 of 22 in the top left-hand corner of his.
All right.
And so within that, opinion 1, broad opinion 1, says the practice standards for mental health professionals functioning in a forensic capacity are applicable to Dr. Watson's undertaking in the index case. So effectively, the first opinion is, here are all the things that we think Dr. Watson was obligated to do. And to our point, Your Honor, it's exactly what the Brown case says is impermissible. You're effectively saying, here's what I think this expert should have, or the standards that should apply to him, similar to Tuning saying, here are the types of things an accident reconstructionist needs to consider. And so when we look at those within the context, there's citing to psychiatric manuals, there's citing to different objectivity and diligence requirements, and all of that's fine, but it's not helpful here because ultimately it doesn't render an opinion or conclusion as to the applicability of any of that, other than to say, I think that Dr. Watson should have done these things. So then opinion 2, which is on page 5, top of page 5, says the information cited in Dr. Watson's report and assessment methods and the records and the treater's therapy notes are not sufficient to support all of their conclusions. Again, I think this is essentially what I anticipate the testimony of Dr. Hagen being. I don't think that Dr. Watson had enough information to render the opinions that he did. And that is precisely what invades the province of the jury. It is the jury's job to assess the credibility of the witnesses. That's actually one of the agreed instructions that the parties have agreed to. It's also an agreed instruction that the parties have agreed to, as was submitted to the court, that here are the ways in which you measure or assess an expert's testimony. And one expert critiquing another expert is not the permissible standard within the evidentiary rules. That invades the province of the jury. And that's, he goes on for 3 pages about the different types of things that he ought to think or wishes or thinks that should have been considered by Dr. Watson. And I'll, as a little anecdote, Your Honor, the rules as it relates to expert testimony do not permit the recitation of hearsay or inadmissible evidence. So if this witness goes on the stand, effectively the question is, what's your opinion? And the opinion is, I don't think Dr. Watson had enough information to render his opinions. And the question becomes, okay, what does that do other than assess the credibility of the witness, which is exactly what the jury's job is, and that would invade their province. And then opinion 3, which is on page 15, which says, again, an opinion focused on Dr. Watson. Dr. Watson's report and assessment.
Wait till you see this doctor testify. If it's the same one I'm thinking of, if it's the woman, she is crazy.
Critiquing the weight or the validity.
The stuff she says is wild.
That the jury
Just wait.
should provide to his testimony. Now, this is an issue that comes up. This is an issue that we've dealt with in Richmond before, in which there's an expert that comes in and says, this was Dr. Ziv in a different case, just anecdotally, Your Honor. I think that this expert did a good job in the process. I think this expert did a bad job in the process. And then the question is to the expert themselves, Dr. Ziv in that context, well, what did you do to assess the material issue in dispute? What did you do to assess causation? What did you do to assess damages? What did you do to actually become helpful to the trier of fact on an issue that they need to decide? And the answer is nothing. They didn't evaluate. Dr. Hagen didn't evaluate Ms. Zwerner. Dr. Hagen doesn't even opine as to causality or diagnoses of Ms. Zwerner. All he's offered to show or to testify to is, I don't think I agree with what Dr. Watson says, effectively. And then the question is, why do we need that? How is that helpful to the trier of fact, other than to assess the credibility of an expert witness, which the Supreme Court has said unequivocally is impermissible?
I think he's got a pretty doggone good argument for that.
In brief, what our response amounts to is the argument that there's a distinction in the law between opining directly or indirectly on whether or not a specific witness is credible and their testimony is credible on the one hand, versus offering scientific or other professional expert testimony to assist the trier.
This guy has no respect for the court, at least visually, in my opinion. He never goes to the lectern, ever, unless he's told to. He always argues from the table. It's weird.
That does not usurp the province of the jury for its quintessential fact-finding function. How do we know this? We know this because, number one, under Rule 2702 of the Rules of Evidence of Virginia, subsection B, it does state clearly that, quote, testimony that is speculative or which opines on the credibility of another witness is not admissible. The key language there is which opines on the credibility of another witness. Dr. Hagen is not going to opine on the credibility of Dr. Watson. What would happen is the crux and thrust of his testimony is establishing that these are the proper protocols and factors that a clinician would rely upon in reaching an assessment. And that is something that the jury needs to hear about to assess and weigh whether or not to assign what weight to give to Dr. Watson's testimony. It falls short of going over and pointing to Dr. Watson and saying, this particular expert lacked an adequate factual basis to support their conclusions, therefore you should disregard it. We can offer a step short of that by testifying, here is what a reasonable clinician would rely upon. This is what you need to rely upon. If you do not do this, then you do not have an adequate factual basis. Then it would be left to the jury to assess whether or not, it would be left to argument of counsel to go in closing and say, look, you've heard testimony from Dr. Hagen that these are the principles and standards you need to rely upon in order to conduct a thorough and proper assessment. This wasn't done here. You heard nothing about that with respect to Dr. Watson. In that case, Judge, there is no running afoul of 2702 subsection B. There is no directly identifying this specific witness you should or should not believe their testimony. That is the problem that these rules are oriented to address. This is also highlighted by the fact that, Judge, there's literally a jury instruction that will be offered in this case on what the jury should consider when they're weighing expert testimony. And this is a model instruction. It's not something crafted by counsel. If you look at Virginia Model Jury Instruction number 2.040, expert witnesses, that provides, Judge, that in considering the weight to be given to the testimony of an expert witness, you should consider the basis for the expert's opinion and the manner by which he or she arrived at it, and the underlying facts and data upon which the expert relied. That's what counsel is referring to when they're saying this is up to the jury to assess and weigh the credibility of this witness. And what's crucial to making that decision, what's crucial information for the jury to assign proper weight to an expert's testimony, is the basis for arriving at their conclusions. That is something that is legitimate game, that is fair game for a expert to opine and give an opinion on for the jury. The jury doesn't know what proper protocols the clinician should follow, or the standards it should apply, or the things that they should do or do not do in assessing and reaching an opinion regarding a diagnosis. They don't know that, and that will assist the finder of fact in weighing that expert's testimony. It could potentially be a step too far to say, look, this expert, in my opinion, did not have an adequate factual basis. I would argue that that's fair game as well, but to the extent that there's any concern in that respect of usurping the province of the jury, we can fall short of that. We need not go that far, Judge. And in fact, we can provide a cautionary instruction, and this jury instruction itself will be offered and say, this is your decision, jury. You assess the credibility of witnesses. That completely mitigates any risk that counsel has raised here. Finally, Judge, I apologize to not prepare case law to pass up to the court. I had to do this on the fly. But I've reviewed Corbin, and here's a key distinction here to emphasize. On page 6, the court emphasized, quote, that the expert at issue, his testimony did not offer scientific opinions to assist the jury in resolving certain factual issues. Instead, it suggested by implication that Dixon's investigation was inadequate and that his testimony was not credible. The crucial language there is that the expert did not offer any scientific opinions to assist the jury. This is something where the distinction here is that Dr. Hagen wouldn't be offering opinions. He would also be offering testimony to establish here are the steps that the clinician needs to apply in arriving at a proper diagnosis. I leave it to you, members of the jury, to determine whether or not his testimony is credible. This is borne out in the case law. There's an example in Faust versus Commonwealth. That's 2024 VAF Lexus 111 from March 5th, 2024. The facts are not analogous, but it stands for the principle that in each of these cases where they deal with this particular issue upon which counsel is relying, the court has always emphasized, when they affirm allowing this type of testimony, they have always emphasized that the expert did not opine either directly or indirectly on a specific witness's veracity or credibility. That's all that the rule contemplates. So, Judge, I ask that you admit this evidence. We can issue proper limiting instructions, but the proper remedy is not exclusion.
And obviously, you're not going to be permitted to ask those questions to your witness, right? In terms of his reliability, in terms of his opinion of Dr. Watson's reliability.
Correct.
Okay. All right. Anything else you wanted to put on the record?
Yes, Judge. If they cannot ask those exact questions, what I think we're all acknowledging is the language of 702B, which says that you cannot opine as to the credibility of the other witness, is what is prohibited. But the reason that the case that's been provided to the court is important is that the court says because there is no opinion, the only thing they are doing by implication is attacking the credibility of another witness. That's the only purpose. And when we assess when we look at the evidentiary rules and we say, okay, it's satisfied 702, hypothetically, because we're not offering an opinion, they're backtracking as it relates to the designation now. What we then have to question is then, okay, does it survive 403? And the 403 question is there going to be an unfair prejudice, or is the jury, in other words, going to take this testimony and use it for an improper purpose, the improper purpose being exactly what Rule 702 prohibits it from doing? And that's what argument of counsel demonstrated. They essentially said, well, we're not going to get to the credibility question exactly, but we're going to ask everything else up until that question, and then in closing argument, we are going to argue that because of what our expert said, they should discredit what their expert said. And so effectively, it's a roundabout way to get to what is prohibited in 702. And if it's prohibited in 702, and that's the reason they're doing it, that is the precise unfair prejudice that 403 seeks to exclude, which is to say you cannot admit something for one reason and then try to argue it for a separate reason in front of the jury, because you're effectively asking them to take a piece of evidence and use it for an impermissible purpose, which is in and of itself unfair prejudice. And there are cases that discuss the possibility of doing this, and I think Ms. Douglas talked about in conferral that Dr. Hagen does this in Virginia Beach. Well, the rule explicitly discusses the difference between criminal proceedings and civil proceedings in this context. 702A2 talks about how in a criminal proceeding, the expert may be, the court finds that the subject matter is beyond the knowledge and experience of ordinary persons, such that the jury needs expert opinion in order to comprehend the subject matter, form an intelligent opinion, and draw its conclusions. It's permissible in criminal cases. That precise language, which is what they're arguing here, is not in the civil rule, directly above it, which by implication, if we're talking implication, and statutory construction, albeit these are rules of the Supreme Court, what we know is that if the Supreme Court intended that to be permissible in a civil proceeding, they would have included it in that section above as it relates to civil proceedings. They did not. They only addressed this particular issue in a criminal proceeding.
All right, thank you very much. All right, court overrules the plaintiff's objection. Dr. Higgins will be permitted to testify.
Your Honor, just out of an abundance of caution, would we be able to meet with Dr. Hagen before he testifies, just to make sure we don't run afoul of
Yeah, are you agreeable to her just instructing him, what he can and cannot based on my ruling?
Yes.
All right, that's fine. So we'll take a short break, and he'll be your first witness.
Yes, we'll read the deposition, read the RFAs, and then call Dr. Hagen.
All right, are there any other experts being called today?
We do. We have Dr. Klingler.
Okay.
I thought we had worked that issue out, given the agreement related to Dr. Shufflebarger, but I understand today that there's objection, so.
All right, then we'll be in a short recess, and as soon as we're ready to start the defense's case. Okay. All right. Thank you very much. Brief recess.
Please stand for the juror. Nine jurors in the box, you may be seated.
All right. Plaintiff, you request a poll. All right. Defense request a poll. All right. Good morning, ladies and gentlemen. Thank you all for coming back. Not that I gave you a choice, but I appreciate it. I hope everyone had a nice weekend. We are going to proceed with the defense case at this time, and you may call your first witness.
Your Honor, we're going to begin by playing portions of Ms. Zwerner's deposition.
Before the shooting on January 6, 2023, did Dr. Parker ever explicitly tell you that she would promise to agree, or promise or agree to protect you from John Doe? No. And this would include protecting you from a potential shooting or any other assaultive conduct by John Doe?
Did she tell me those words?
Yes,
Is that what you're asking?
before the shooting, did she ever explicitly promise or agree to protect you from an assault by John Doe?
No.
On January 6, 2023, was the only time you communicated with Dr. Parker directly before the shooting was when you went to her office at lunch to tell her about the behavior in the lunchroom?
Yes.
After that conversation, did you have any further communication with Dr. Parker?
No.
Do you have any direct knowledge, personal knowledge, of how Dr. Parker responded to any report regarding whether John Doe had a weapon?
Yes, what Mr. Rawls told me when Mr. Rawls came and spoke in my room.
I'm asking for personal knowledge that you yourself overheard from Dr. Parker.
Herself speaking?
Yes.
No.
At the time you spoke with Dr. Parker in her office on the morning of January 6th when you left the lunchroom, did you have any knowledge that John Doe might have a weapon of any kind?
No.
Did you have any reason to suspect he might have a weapon of any kind?
No.
But you received warnings after you spoke with Dr. Parker about John Doe potentially having a weapon?
Yes.
and then you received subsequent information throughout the day about John Doe, or you either observed or heard things that made you concerned that he might have a weapon.
A little bit, yes.
You never told Dr. Parker that you had reason to suspect that John Doe had a weapon, correct?
I only spoke to her at the lunchtime.
And you didn't convey the new information that you gained throughout the day to Dr. Parker,
I only spoke to her at lunchtime.
correct? Did you ever isolate John Doe from the class on January 6, 2023?
No.
And you never sought out guidance, Ms. Palladini or Mr. Rawls, on January 6, 2023?
No.
All right, and for the record, ladies and gentlemen, that video and the transcript are Court Exhibit E.
Your Honor, I would next like to read the 4 requests for admissions.
All right. Ladies and gentlemen of the jury, before cases come to court and are actually presented before you, there's something called discovery that happens where the parties exchange information. Defense counsel is going to read to you from some of that information in the form of what was a request for admissions. This is going to be admitted, the parts that she will read as Court Exhibit D.
Defense request for admission 4-2, Ms. Zwerner. Admit that on January 6, 2023, before the shooting occurred, you did not receive any communication from the defendant expressly promising or agreeing to protect you from any risk of harm by John Doe. Response, admitted. Request for admission number 11. Admit that before the shooting on January 6, 2023, you did not communicate to defendant there was a reason to believe that John Doe might possess a firearm. Response, admitted. Request for admission number 12. Admit that on January 6, 2023, the only time you communicated directly with the defendant before the shooting was when you went to defendant's office and told her about John Doe's behavior during lunch. Response, admitted. Number 18. Admit that on January 6, 2023, before the shooting occurred, you did not receive any communication directly from the defendant acknowledging that she knew that John Doe might possess a firearm. Response, admitted.
All right, and the court will provide you as Court Exhibit D a redacted version of that with the 4 answers. So we'll need to redact that. Okay. All right, next piece of evidence or witness.
Witness Dr. Lee Hagan.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Can you please state your full name and spell your last name for the record?
Lee D. Hagan, PhD, and the last name is Hagan.
And what is your professional address?
I'm in Chesterfield, which is near Richmond.
And what is your profession?
I practice clinical and forensic psychology.
When were you first licensed?
In 1982.
In what state?
That was in Georgia.
Are you licensed in Virginia as a clinical psychologist?
I am, and I have been since 1982.
Can you please tell the jury about the type of practice that you have?
I consult with attorneys and testify, as I will today.
In the areas of forensic psychology?
Yes, where mental health issues are concerned.
And Dr. Hagan, can you tell the jury what is forensic psychology?
It is that intersection of issues of human behavior and legal questions.
Dr. Hagan, will you please tell the jury a little bit about your educational background?
Yes, thank you. I have an undergraduate degree in psychology from University of Virginia, and then I earned a master's degree in counseling from UVA. Thereafter, I went to the University of Missouri in Columbia, Missouri, where I earned a doctorate in psychology.
Do you have any postdoctoral training?
After earning my doctorate degree, that's the PhD, I have hundreds of hours of continuing education, almost all in the field of forensic psychology.
Dr. Hagen, do you have any advanced certification?
I do. It is my privilege to be a diplomate of the American Academy of Forensic Psychologists. A diplomate is someone who's been granted a diploma, thus diplomate.
And describe for the jury what the board certification process entails.
When I went through the process in the 90s, there were 3 hurdles I had to clear. First, I had to show sufficient evidence that my practice was indeed forensic in nature and that I wasn't a psychologist who just occasionally showed up in court. I cleared that hurdle. And the second hurdle, I had to write up 2 reports or case analysis from different areas of law, and that was submitted to a committee to see if my work was up to snuff and met their standards. I cleared that on the first pass. And then finally, I flew across country for an oral examination by a panel of other psychologists who were already board certified. I cleared that on the first pass.
And you mentioned that you are a forensic diplomate. How many forensic diplomates are approximately in the Commonwealth of Virginia?
Well, of those who are in full-time private practice, last check there were only 11.
Are you a member of any major professional organizations?
I am.
Can you please tell the jury about those?
The American Academy of Forensic Psychology, the American Board of Professional Psychology, the Psychology and Law Society, and the Association of Family and Conciliation Courts.
Have you provided training for students?
Many times. For about 10 years, I presented each semester to the third-year law students at University of Richmond Law School. I was the director of psychology training for the doctoral internship program at McGuire VA Hospital in Richmond. It's been my privilege over the years to have individual tutorials, intensive independent study students from Virginia Union University, Virginia Commonwealth University, University of Richmond, University of Miami, Vanderbilt University, and William and Mary.
Do you provide continuing education for other professionals?
I certainly do. I've given many continuing education presentations to mental health professionals and others.
Do you provide consultation and supervision for other professionals in their forensic work?
Not supervision, but lots of consultation. In fact, just yesterday I was assisting another psychologist who had a thorny issue involving her court testimony. This Friday,
You can't. Anyway,
We'll
you wanna
move
object?
on.
Okay, sustain.
Okay. Dr. Hagen, how many psychological assessments have you conducted?
at least 1,000.
And other than for private legal firms like mine, who else have you conducted evaluations for?
For the court-appointed attorneys, for prosecutors in a variety of states, for the Virginia Attorney General and others.
And how many times have you qualified as an expert in court?
477,
And is that in state court as well as federal court?
state and federal court.
Is that only in Virginia, Dr. Hagen, or other states?
No, I have qualified as an expert in clinical and forensic psychology in Virginia, North Carolina, Maryland, Delaware, Pennsylvania, West Virginia, Ohio, and if I didn't say it already, Florida and Texas.
I would like to, at this time, move to qualify Dr. Hagen as an expert in forensic and clinical psychology.
Any objection or request for Woodyear?
No, Your Honor. I note the objection.
Continuing objection, correct.
Yes, Your Honor.
All right, he is so qualified.
Dr. Hagen, who hired you?
You did.
And what were you hired to do?
To review records and develop opinions relevant to this situation.
And what specific issues were you asked to address when mental health professionals are in a forensic capacity offering opinions on a mental health diagnosis in court?
One, whether the standards for forensic mental health apply for a person conducting an assessment in a situation like this, and also to offer opinions on the methods and procedures that a mental health professional should use when conducting an evaluation and rendering a diagnosis, with full anticipation that that information will be used in court. And then finally, the third of 3 points, to offer information about the problems when offering a mental health diagnosis in court.
And have you ever met the plaintiff, Ms. Zwerner?
I have not.
What about Dr. Parker, our client?
No.
And I want to ask you to tell the jury about the information that you considered. Mr. Coleman, could you just publish that to Dr. Hagan only?
So there were 4 categories of information that I considered. The first was information from the plaintiff that she provided to the defense side that included her complaint and some other information. The second category I considered were the plaintiff's medical records, including her out-of-work notice from...
I don't know if the witness isn't offering any opinions pertinent to the plaintiff. 703 does not permit the witness to opine or just begin to testify as to all the information that they relied upon.
I'm sorry, he's just testifying to what he reviewed, and you're objecting to that?
Correct.
Okay.
In other words, he's just saying these are all the things I looked at.
That's overruled. It's relevant.
Okay. So the plaintiff's out-of-work note from February 14 of 24, and then there were some counseling records from a group called Abundant Life, both before and after January 6 of 23, and there was the Boulders Ambulatory Surgery Center, the North American Partners in Anesthesia, the Ortho Virginia records, the Riverside Orthopedic and Sports Medicine records, the Riverside Physical Therapy records, the Riverside Regional Medical Center X-ray records, the primary care physician records out of West Point Family Medicine, and the plaintiff's radiographs, as well as the Newport News Fire Department's patient care report from January 6 of 23. So that's the information provided by the plaintiff, followed by the medical records I reviewed. Then there were 2 other categories, the third being the depositions, the plaintiff's 2-part deposition, and I'm not sure if I can...
I think you can say what he reviewed, Your Honor.
Okay, as well as the plaintiff's mental health expert report and designation, Dr. Watson. And then there was the 4th category were other materials that I considered, and those included the following. Of course, Dr. Watson's report, and then Dr. Watson's deposition, the plaintiff's Empire Beauty School records, her grades, the requirements, her attendance, her performance, as well as the plaintiff's emails and her text messages before and after January 6 of 23, her Facebook posting, text messages between the plaintiff and her colleagues, and text with friends and other colleagues, and there's an agency in Virginia that licenses professionals to do certain things like hair, nails, and so forth. That's called the Virginia Department of Professional Occupation Regulations, to verify the plaintiff's license, and also to see what their requirements are for a person to become licensed as a hair person.
Dr. Hagan, is the information you considered of a type usually relied on for the purpose for which you were hired?
It is.
And are there any issues about which you will not be offering opinions?
Several. I'm giving no opinions whatsoever on liability. I'm giving no opinions about anyone that I haven't personally evaluated, and I'm not going to get out of my lane and reach into the job of the jury with any ultimate opinions.
As a result of the information you considered, did you form opinions?
I did.
And are the opinions you formed held to a reasonable degree of psychological certainty?
They are.
Dr. Hagan, when assessing whether the forensic practice standards apply, what standards apply to a mental health professional when offering a diagnostic opinion in court? Tell us about the forensic standards that apply both to a psychologist and a psychiatrist.
One of the sources of standards comes from the American Academy of Psychiatry and Law. And that standard says that a mental health professional's
Objection, hearsay.
You have a response?
I mean, he can state the basis for his opinion, Your Honor. That's clear in the case law. Otherwise, inadmissible hearsay forming the base of an expert opinion may be admissible for a purpose other than the truth, such as to demonstrate the basis of his opinion.
Are you personally familiar with the forensic standards?
I am, Your Honor.
Overruled.
So that standard from the American Academy of Psychiatry and Law says that a mental health professional's objectivity is enhanced when the professional considers all of the sources of information available when forming an opinion to be offered in court. That's one. Also, with which I am very well familiar, the American Psychological Association's Ethical Principles and Code of Conduct, 9.01, says that when offering an opinion, if the evaluator is aware of certain information that he or she didn't develop or wasn't available but could be relevant and helpful, then they have a responsibility to tell their audience and their reporter through their testimony what information wasn't available and how the absence of that information could negatively impact the conclusions they ultimately drew.
And Dr. Haken, as a result of everything you reviewed, what opinion did you reach about whether the forensic assessment standards were applicable to a mental health professional's assessment?
I offer the following opinion to a reasonable degree of psychological certainty. Those standards which I just cited are applicable when a mental health professional offers opinions having assessed a person for the purpose of litigation, that is, for going to court.
And what is the responsibility of a mental health professional when offering an assessment of a person in court for litigation purposes?
To explore all of the sources of information that could be relevant and helpful, and to identify those sources that could have been useful but weren't available or weren't available at the time, and to state what impact the absence of that information could have on their ultimate opinion.
And does that relate to issues about the amount of the source of information that the mental health professional has?
It does.
Okay. And what about reliance on self-report versus other information?
Well, self-report means when the person who's being evaluated comes in and tells the evaluator things, information. A good starting point. But it's not the end point. It's important for an evaluator to consider all of the information, including information that may not line up exactly with what the person said. Just like in court, under direct exam, you're not just going to hear my answers to these questions. There'll be cross-exam, so the jury can figure out what weight to give what I have to say. That's analogous to when an assessment is done. You would ask the person, how are you doing, how are you feeling, what's going on, what seems to be the problem. But when it's done with reasonable foreknowledge, that is, you know in advance that this is going to be used to assist a judge or jury in determining a legal fact, then there is a responsibility to develop collateral informants and to review records so that you have the full movie of the person's life rather than a snapshot at a moment in time.
Does the mental health professional rely on any psychological testing?
It,
It's outside the designation. I don't know what we're talking about.
All right. But do you have a response?
I'm sure it's in his designation. Do you want me to? Your Honor, the report is 20 23 pages. I will not spend the time going through it now. I'll move on to something else. There's plenty of other things we can talk about.
That's sustained. Go ahead.
Okay. Does the mental health professional consider the person's adjustment prior to the index event for which they have been engaged?
Yes, the mental health professional doesn't cherry pick the information.
Object. The question isn't, does this person do this or that? This person's been proffered to testify as to what a mental professional ought to do or should do. And the framing of the question is, do they do this? Do they do that? Do they do this? Isn't appropriately framing the issue within the context of what he's been proffered to testify to.
You have a response?
I can rephrase the question. Should a mental health professional consider records and information prior to the index event?
Yes.
And where would one gain that type of information?
Well, from what the person tells them and what they read from other sources. They need to have an appreciation of the context of why are they even getting this referral? What's the question to the evaluator?
Does the mental health, or would a mental health professional consider functioning prior based on collateral interviews and such?
Absolutely.
And Dr. Hagan, what is the mental health professional's responsibility if they don't do all of the things that you just said?
They have a responsibility to their audience to say, here's some things that I didn't develop, here's some things that I sought, but they weren't available to me when I formed my opinion, and here's how the absence of that information could impact the opinion that I developed.
Do you hold all of your opinions to a reasonable degree of psychological certainty?
I do.
Go ahead. Thank you, Dr. Hagan.
My turn?
Yes. This is a...
This roadmap.
Yes, we're not doing a roadmap.
Roadmap every witness.
You can do a roadmap with your witnesses, but not with mine.
All right, I'm going to sustain the objection. Don't need to give him a roadmap.
Dr. Hagan, you ever heard of the phrase armchair expert?
Yes.
Okay. And you testified earlier that a job of a forensic psychologist is to, I think it was, assess the intersection of human behavior with legal questions. Is that right?
That's the definition of forensic psychology.
So that's a yes? That's
It's not a yes. I'm clarifying that that is the definition of forensic psychology. It doesn't dictate what a forensic mental health professional does in each case. It needs to be driven, the conduct in each case needs to be driven by the standards that apply and the facts specific to the case.
And that's your opinion because you, in fact, didn't address the intersection of human behavior and legal questions in this case because you didn't evaluate Ms. Zwerner. True?
False.
You evaluated Ms. Zwerner?
No.
That's all I need to know. You did not evaluate Ms. Zwerner, correct?
I have not.
And so when you said you performed 1,000 psychological assessments, all 1,000 of those are people who are not in this courtroom. True?
That's true.
And you said that you testified, hundreds and hundreds of times. You testify almost every week.
No.
You testify a lot.
477 times.
Did you testify last week?
Not last week.
Soon, recently.
In October.
Okay. And when you were asked what you would be opining on, you agreed that you wouldn't be offering an opinion on liability, correct?
True.
And in your experience in forensic psychology, that's a, quote, legal question, correct?
Well, it's outside of my area of expertise, the liability question is. So I'm going to stay in my lane.
All right, let's stay in the lane then. And that lane in other circumstances included actually providing an evaluation of somebody at issue, true?
I have done that, yes.
And you understand that the court can order that you provide an evaluation of somebody if it's requested?
The court can order it, yes.
And that defense counsel, if they wished, could ask you to perform an evaluation, true?
Objection, Your Honor. First, it's leading. It's not relevant. That's not an issue before the court.
All right, well, it's cross-examination. I'll allow him to lead, but what about relevance? You have a response to that?
Yes, Your Honor. The assessment is he's been offered to testify as to what a forensic psychology is helpful to do. And in this case, we're trying to figure out what he did, what he didn't do, so that the jury can understand how best to use or to evaluate his opinions.
Your Honor, Dr. Hagan has no input on defense counsel's decisions with respect to whether there would be an evaluation. He was very clear that he said he did not personally evaluate her and didn't need to offer his opinions.
Can you ask your question again? Mr.
Sure.
Neal?
Were you asked to evaluate Ms. Zwerner?
No.
Overrule the objection. Go ahead.
Did you ask to evaluate Ms. Zwerner?
No.
You understood that a question that this jury would be asked to decide is damages, correct?
Yes.
You understood that a question that this jury would be asked to decide is causation, correct?
Yes.
And you explicitly within your report stated, give me a moment here, that you will give no opinions about persons whom you have not evaluated, true?
True.
So you're not opining as to any, you did not offer any opinions as to her mental health diagnoses, true? You did not offer it in your report, true?
I'm not giving any opinions about her diagnosis. I have opinions about how the diagnosis was reached, the methods and procedures, giving no opinions about the plaintiff herself.
So to answer my question, the answer is yes, correct?
The answer is the one that I just gave.
Okay. And so, when we're addressing this specific issue in this case regarding post-traumatic stress disorder, you did not render any opinions regarding post-traumatic stress disorder, correct?
I rendered opinions about how that assessment was done. I'm not giving any opinions on the truth or the validity of the opinions.
That's because you didn't want to get your hands dirty and
It's
actually
because I'm
address it.
staying within my lane and not offering any opinions about anyone that I didn't evaluate myself.
Because that would violate its own ethical rule, true?
I think that is true.
There's a Goldwater rule that says you shouldn't be offering opinions about people who you haven't assessed personally, true?
I'm not familiar with it under the Goldwater, but I know under the American Psychological Association's Ethical Principles and Code of Conduct, published in 2016, section 9.01 through 9.03, it says you shouldn't do that, and I'm not doing it.
Thank you. No further questions.
Any redirect based on that, Cross?
Just a little follow-up. You were asked about whether you needed to evaluate Ms. Zwerner to offer your opinions today,
I was asked that
and you addressed that when you spoke to the jury the first time and said you did not need to do that.
first time and second time and third time. Yes, ma'am.
Thank you, Dr. Hayden.
May he be excused?
Yes.
All right, you are excused from your subpoena. Please don't discuss this case, all right? Thank you. You may leave the courtroom. All right, next witness.
Next witness, Dr. Klinger, but I think there are some issues that Mr. Knyaz wants to address.
All right, before we have more testimony, we are going to allow the jury to take a quick break, and we will address some legal matters.
Please stand for the jury. Thank you. You may be seated.
All right, so I have the expert designation from the defense, and I have, starting with Ms. Klinger's designation, starts on page 17. Is that what we're working off of?
Yes.
All right, very well. All right, I had withheld a finding after our pretrial motions day on this, and have you tried to consult and solve any issues?
The defense counsel has sent us what they intend to proffer, and I think that, and I showed them some highlights that I have that I object to this morning. So I don't know what you'd prefer, whether you'd like them to proffer and then we object, or vice versa.
I guess I would probably prefer them to proffer at this point, to sort of narrow those things, and then I'll allow you to respond.
Yes, Your Honor.
Your Honor, my understanding is it doesn't have an objection to everything. I think for us to proffer things that are not objected to, it might be best to just address the specific. And I have a marked up version of what I said last night, if that would help, Your Honor, rather than having to read off the.
Any objection, me taking a look at that?
No, Your Honor.
All right. All right, the court accepts as defendant's proffer pages 17 through 28 of the expert designation and opinions expected to testify to, with the line throughs being done by the defense. All right, Mr. Benioff. This, I guess, for the record, would be Court Exhibit F. Right.
Just so we're interpreting, my understanding is that they've struck through the things they're not providing.
That's my understanding.
Okay.
Yes.
So first,
Just one point of clarification, Your Honor. On the issue of gross negligence, there was an agreement with Dr. Shuffleberger not to use the word gross negligence, and in the email that I sent last night, it spoke about what Mr. Benioff refers to as the buzzwords, which are in the jury instructions that have been offered to the court, such as indifference, lack of any care, that sort of thing. So I just want to make sure that when the word gross negligence is written, that Your Honor understands that she would be speaking to that, but just in more phrases that are in the jury instructions and some of the case law.
all right, so if we can start on page 18, Judge, there's a line that suggests, and this is the second paragraph, it's the third or fourth sentence down, that says that Dr. Klinger is expected to testify that Dr. Parker did not show indifference to plaintiff as constitutes utter disregard, caution amounting to a complete neglect of safety of the plaintiff with respect to her involvement in the education of John Doe, including but not limited to January 6th. The issue there is that it seems to suggest that there's going to be testimony proffered that does not relate to January 6th, that actually is regarding to sort of educational duties generally before January 6th, which I think is impermissible and not an issue for the court, for the jury to decide in this case. And I figured I'd go one by one.
Right, so, I mean, I guess we need to clarify that then.
Your Honor, I think I can short circuit this. She's not offering any opinions beyond January 6th. That was just an omission on my part when I was marking out.
Okay.
Yeah, I think I caught it in some places, but not everyone.
All right, so if we limit that to on January the 6th, you've no objection, correct?
Yes, no objection, with the exception that there seems to be later discussion of how she has educational duties, and whether she met those educational duties, I think, is an issue.
Okay, well, we'll strike, just once again, for the record purposes, I'm gonna use X's since you lined things out. I'm gonna use X's on this exhibit.
Thank you, Your Honor. That's a good
All right.
idea.
Okay, so that just is limited to on January the 6th. All right, next, Mr. Benioff.
All right, if we go to the bottom of page 20, Judge.
I'm also initialing those X's. All
Thank you, Your Honor.
For the record. All right, go ahead.
Bottom of page 20, there's a very last sentence says, Dr. Klinger is expected to explain to the jury that an assistant principal is not a law enforcement officer, does not receive law enforcement training, generally receives little education and training from a school board regarding how to respond to potential threats in the elementary school setting. There's a couple issues with this, Judge. First, I think it is well within the province of the jury that an assistant principal is not a law enforcement officer, and so in that context, it's not helpful to any issue at fact. And then furthermore, this generalization as to what is trained or what information is provided to an assistant principal without being specifically focused to the case here, in other words, Newport News or even Dr. Parker, invites the jury to speculate as to whether that's true for Dr. Parker or whether Dr. Klinger is just saying this is generally true for everybody, but who knows how it applies in this circumstance.
Counsel, can you identify which page reference?
Sure, it's bottom of page 20, top of page 21.
All right. Any response to that?
Just a moment, Judge. Judge, I'd like to respond with respect to testimony that stating that Dr. Parker is not a law enforcement officer who receives limited training. I would agree that to the extent that she would testify that to be obvious that Dr. Parker is not a trained law enforcement officer, that is common knowledge. The jury can draw that inference from their own evidence and through their own independent assessment of what they hear. But I do think that it is the proper purview of Dr. Klinger to shed light on and explain to the jury that there's often an intersection between the roles that are typically thought of for law enforcement in terms of searching students for contraband, ensuring safety, that can overlap with the obligations of an administrator. And Dr. Klinger can explain to the jury that just because administrators and school teachers and staff often have to fulfill these roles and undertake certain responsibilities to conduct these types of searches, that does not mean that they're necessarily trained to the same degree that we would expect of law enforcement officers.
All right, I'm going to grant it as to is not a law enforcement officer. I'm going to deny it as to the rest with leave to cross-examine on those issues as it particularly applies to this case.
Yes, Your Honor. Right, ready for the next one?
Yes, sir.
Last paragraph, page 21, big paragraph. It's all about Dr. Klinger talking about mental health crises in children generally and attempting to, I think, equate that to circumstances here I mean, we just heard from a forensic psychologist that says we can't offer opinions ethically as it relates to people we have not evaluated, and this seems to do it carte blanche. And she's not an expert in the field of psychology or psychiatry, nor is she an expert in the field of determining what is a pandemic in the context of mental health crises in America. And ultimately, it's not a helpful issue to the jury or the trier of fact in this circumstance.
All right.
Your Honor, we'll strike that whole paragraph. She's not going to be testifying as to that. It begins on page 21. Dr. Klinger is expected to explain it, ends with overturning desks.
Court is in agreement. All right.
Next paragraph, page 22, we also object to, Your Honor. This is that Dr. Klinger is expected to testify or educate the jury upon weapon or gun talk or mimicking in an elementary school setting. Again, this is, essentially attempting to proffer inadmissible hearsay to say that to normalize this behavior, even though there's no basis for that opinion in the context of this case, or to be helpful in this circumstance. We don't know that any of the people here had any circumstance or observation of this gun talk or weapon talk or mimicking, and that invading this would sort of insert an issue in front of the jury about this generalization that is inapplicable.
Why would an expert be allowed to testify to this?
Judge, first, I think that she can testify based on her training and experience that these phenomena, including children who commonly mimic guns, commonly mimic weapons, is a frequent occurrence in schools. She can testify based on her training and experience in decades in serving as both a teacher, an administrator, an authority figure in these school settings, that this is something that is routine, and that is something that is not common knowledge to the jury, that would assist them in deciding material facts at issue in this case, including whether or not Dr. Parker's response to the reports she received were reasonable in light of the information that she received. We've heard evidence in this case that a number of the reporting parties who interacted with Dr. Parker subjectively believed that the object that JT might have possessed was, in fact, a fake or toy weapon. There's also been testimony from Alonzo Rawls that it's also very common for part of why he thought that there was not a credible threat or credible report at the time he spoke to Dr. Parker was that in his experience in dealing with children, they often confuse weapons with legitimate or innocuous innocent items, such as pencils, erasers, other objects. So this is something that Dr. Klinger can add her experience on. It would not be cumulative, it would be corroborative. In addition, it's something that would come from, will be necessary to provide context for the rest of her opinions. It dovetails nicely into the balance of her testimony, Judge. So for all those reasons, I ask that it not be excluded.
And I'm going to sustain the objection that is something that is can be commonly observed and taken as an experience. All right, objection noted. All right, next.
Your Honor, the next is the beginning part of the very next paragraph, where it starts with Dr. Klinger is expected to testify, and then it goes on to essentially state that Dr. Klinger is going to offer an opinion that what has been reported in the media or the press is inconsistent with her review or the factual circumstances of this case as she's found them totally impermissible. We've told the jury that they can't decide this case on what's out in the press, and to invite a witness to now talk about what they saw or heard in the media compared to what they've seen or heard in deposition transcripts, which, as Mr. Hogan's argument illustrates, what happens in depositions isn't always what happens in this courtroom, because Mr. Rawls never testified to those things, nor has Amy Kovac, despite their attempts to put in a video, testified to the thing that he said. And so for an expert witness to say, what I saw out there is not consistent with what I've seen in these papers, helps the jury nada.
You have a response?
Briefly, I would only say that to the extent that opposing counsel may open the door to the subject, it would be proper. But I agree with counsel that this is something that should be elicited on direct, just injecting issues in the public domain into the court of law here. However, I ask that we have leave and reserve the right to explore those issues if they open the door to it.
All right, so you agree that Ms. Hogan, you agree that they have not opened the door at this point with Shufflebarger's testimony, but may on cross-examination with your witness, is that correct?
That's correct, Judge.
All right, do you have any problem with that?
No, Judge.
Okay. All right, now let me make a note on this. So the objection is granted to the extent that the door is not open.
I don't think the entirety of page 23 ought to come in, Judge. Let me take it one by one.
And so we're skipping the rest of that paragraph on 22. You're fine with we're now going to page 23?
Yes, Judge.
All right.
So page 23, when we look at the second paragraph, Dr. Klinger is expected to testify, and this is, again, involvement in education prior to January 6, 2023. As I articulated before, I think is irrelevant to the issues at bar. And then it talks about how public schools must follow federal and state laws which require that all children, even those with disabilities and those prone to disciplinary problems, including violence, receive a free, appropriate public education. Again, that's not an issue to be decided in this case, nor is it relevant or pertinent to an issue to be decided in this case.
Any response?
Your Honor, I think we can short circuit this as well. Given the narrowing of the case by the plaintiff, we can omit probably all three of those paragraphs on 23.
Okay. Without objection, court agrees. All right.
That brings us to, at least in my view, the last paragraph on page 24, which is next. This is, and I understand from opposing counsel that there isn't going to be an attempt to parrot or to demonstrate any inadmissible hearsay or hearsay statements, but just to assert it for the record, essentially this paragraph attempts to do today, what they attempted to do yesterday, as it relates to video body camera footage.
All right, so it's all hearsay.
All hearsay.
From what I see. All right, any response?
Yes, Your Honor. I anticipate that we'll revisit these arguments later today, and so we can rule on them at the appropriate time. But I would just say that I would identify that none of these statements will be offered for the truth of the matter asserted. They are non-hearsay. They're also relevant and germane to this case. This will be established at this subsequent point in this hearing when we address those evidentiary issues.
Right, but not through this witness. Do you agree with that?
What I would say, Judge, on this point is that Dr. Parker, under Carter versus Commonwealth, as well as the Castillo case, a whole line of cases establishing that an expert may testify even on direct examination to an inadmissible, otherwise inadmissible hearsay testimony, provided it is offered for the limited purpose of explaining the basis of their opinion. That can be cured. Any risk of the jury not understanding that can be addressed with a proper limiting instruction.
All right, I'm going to sustain the objection. I'm also going to find that it's more prejudicial than probative. All right.
That gets us to page 25, the second to last paragraph. There's a sentence that begins with, rather, Mr. Rawls testified in his deposition. And again, it's in the event that they ask her to parrot deposition testimony, it's impermissible. And I can further illustrate the argument, but it's 702, 703.
Okay, so that's that whole sentence.
Correct, all the way until the
end of the paragraph. Correct. All right, any response?
Judge, I stand on my prior arguments. This is the same issue. They can elicit this even on direct examination, otherwise inadmissible hearsay testimony, provided that it is offered for a limited purpose, namely to establish and explain the basis for an expert's opinion. I would note as well, Judge, with respect to the prior issue, some of this may be necessary or relevant to the subsequent evidentiary rulings as to the admissibility of video statements from Ms. Kovac that will be addressed later in these proceedings. I'd ask the court, to the extent the court sustains any objection at this stage, that we have leave to revisit these arguments at the appropriate time.
So I think they can have her testify to what she relied on, but I agree that he cannot parrot this is what Mr. Rawls said during the deposition. So I think it needs to be couched in the language by your expert that she relied on information provided in depositions, and from her understanding, the following things occurred. But is there an objection to that?
There is, Judge.
Okay.
And the reason is that while I agree the expert may draw conclusions upon otherwise inadmissible testimony, that's 703, the inquiry into those otherwise admissible testimony may only be done on cross-examination and cannot be proffered in direct. And so if I agree that they said, and in your review of these facts and information, did you review the deposition of Mr. Rawls? Yes. And did you rely upon the testimony of Mr. Rawls in forming your opinions? Yes. And what are those opinions? Here are my opinions. I agree that that's permissible, but the question of, and was there a determination that Mr. Rawls made that you found reliable that you then relied upon in your testimony? Yes, his belief was X. Is whether it parrots the statement or not, you're getting into facts and circumstances that are inadmissible through this medium. You know, Mr. Rawls testified to what he found and what he didn't find. And it may be an inquiry that's permissible in cross-examination, and that's addressed in 705, where it says in civil cases, an expert may testify in terms of opinion or inference and give reasons, therefore, without prior disclosure of the underlying facts, unless the court requires otherwise. The expert may, in any event, be required to disclose the underlying facts or data on cross-examination. So that's what we're talking about here, that distinction between the two.
Judge, may I respond briefly?
Hold on, let me read the statements, then I will let you.
Thank you.
right, so really there are two conclusions in this paragraph they're attempting to solicit.
I agree.
Okay. First one being, at the time of the shooting, it had not been determined that there was a credible threat, right? That's the first.
Correct.
And then it says and. Then the second conclusion, or facts, that until the shooting occurred and he went into Ms. Zwerner's room where he determined that John Doe was the shooter, he did not believe that anyone at the school was at risk of harm by John Doe that day. So basically, Ms. Hogan, you're asking her to testify to conclusions, or her drawing conclusions that based on his statements. Is that correct?
No, what I would say, Judge, is she would be offering this testimony to explain the basis of her expert opinion. And part of that is that's expressly contemplated under 8.01-401.1, which controls the admissibility of this type of evidence. That's been interpreted by the Court of Appeals in Castillo versus Loudoun County, the 68 VA Act 547. It's a 2018 case, drawing on a huge line of authority. The court said unequivocally, it acknowledges there's a dichotomy between what's allowed on cross and on direct with experts in civil cases. Independent of that, regardless of that, additionally, quote, the otherwise inadmissible here statements forming the basis of an expert opinion may be admissible for a purpose other than their truth, such as to demonstrate the basis of the expert's opinion. They cite Cartera versus Commonwealth, settled precedent that is 9219 VA 516 from 1978, and that was a case where it wasn't just a vague description of hearsay statements made by third parties who were not present in the courtroom. There were explicit statements regarding the patient's symptoms and diagnoses that were admitted into evidence. And those were things that they were the statements themselves. The difference is that an expert can talk about those things provided that the jury is instructed this is to be considered solely to understand the basis of her opinion. So I would contend, Judge, regardless of whether we're referencing verbatim discrete statements or just characterizing them in a general form, this is admissible. It is contemplated under the law, provided that it is clear to the jury that this is not to be considered for its truth, which is not even offered for that purpose. Regardless, Judge, I would also say that looking at the statements themselves, I'm not asking Dr. Klinger to talk about or say that she made a determination based off of Mr. Rawls' conduct or his investigation. I just need her, the goal here is to have her testify that these were statements that she relied upon that will illustrate whether or not proper protocols by the administrator were followed in this case. Those are the material issues before the jury. And so all this can be cured with a limiting instruction. It is expressly contemplated under the law. If you look at Castillo, they cite at least 2 other cases supporting this well-established principle.
And the last word?
Yeah, Castillo's a criminal case, and 703, which is the same as 801-401.1, which Mr. Hogan cited to, explicitly differentiates civil cases from criminal cases. And what we're risking here is the precise thing that they're saying they don't want to that they're not going to do is exactly what they're offering it for. You can't in one sentence say, we're not offering it for the truth of the matter asserted, but then we want to show it to show the reliability or the basis for the opinion testimony of the expert. If it's not for the truth, then why did the expert rely upon it factually if it's not true? And so to say we're not offering it for the truth, but we're showing it to show what she based her opinions on is talking out of both sides of your mouth.
I find that that's more prejudicial than probative. It also calls for speculation. So you're allowed to ask her, did she review and read the deposition, and based on the statements by Mr. Rawls in that, did she come to conclusions? I'm not going to let her testify to what she believed Rawls' conclusions were. I think it's more prejudicial than probative and calls for speculation.
I understand, Judge. I respect the court's ruling. One thing to flag for the court. My understanding from the court's prior deferred ruling or ruling with respect to video evidence coming from Corporal Blythe, which contained Ms. Kovac's statements, I believe, and I took the court's comments for the bench to articulate that evidence may be conditionally relevant. If there's evidence that comes in our case in chief that establishes the requisite nexus to let this come in and make it relevant, then you would reconsider those issues. This may be the opportunity here. Dr. Klinger, if she's testifying as to how the reporting parties and intermediaries that interacted with Dr. Parker, what they subjectively believed and thought, if she's able to establish that as a factor for assistant principal to consider, that is what what this is oriented towards. It's not designed to elicit inadmissible hearsay or to prejudice their case. It is simply meant to explain, these are the documents that I relied on, this is what they said, here is why they are important. Dr. Klinger will testify that as an administrator in determining whether, when, and how to respond to information, they need to rely and depend on their subordinate staff, the first-line responders. And that includes their subjective assessment of the credibility or reliability of the reports they have first-hand knowledge of. This is all will come from Dr. Klinger, and that will establish the springboard for this additional evidence. So I ask the court to consider that And to the extent that this court has ruled already on this objection, I ask the court to reconsider it and revisit it when I seek to introduce Ms. Kovac's statements through the video testimony.
Well, through this witness, it's going to be the same thing. I mean, she can testify what she looked at and what she considered and what conclusions Ms. Klinger, Dr. Klinger, can respond to, or relied on and then formed her opinion based on, and what that opinion was, but not the exact statements. I'm not going to let that.
Understood.
They're more prejudicial than probative. So.
Understood.
Just for
Okay.
clarity, Your Honor, Dr. Klinger can testify that the material she reviewed, that it had been concluded that there wasn't a credible threat at that point,
I mean, that's her conclusion. If she's testifying that that's her conclusion, I'm allowing that.
without saying it came from Mr. Rawls,
Correct.
or that it was a toy gun, but not saying who said it.
Correct.
Okay.
All right, next.
Page 26, Judge. Second paragraph. Sentence that begins with second sentence. Dr. Klinger is expected to explain to the jury that a student in Mrs. Werner's class was interviewed by law enforcement and said the following things. It's pretty much the same thing that we just addressed.
And I'd make the same ruling. I understand you have the same arguments. I'd make the same ruling. She can testify to what she relied on, that there were statements, but not testify to those statements.
All right, next page, page 27.
And hold on, let me highlight specifically.
Yes, Judge.
And so really, it's just that in that paragraph, first full paragraph, partial lines of that paragraph. If that paragraph has 1, 2, 3, 4, 5, 6 lines, it's the last two. So basically, told interviewers that Art told Miss Werner that John Doe had a gun, and Miss Werner told him to sit down and save it for later. Those
Right.
okay.
That second paragraph,
Correct.
the first sentence is fine. This second
Okay.
part of it's out.
All right. Finally,
Last page, almost. Page 27. The paragraph that starts with additionally. And it says, Dr. Klinger is expected to explain to the jury the extremely rare nature of the incident at Richneck, and that John Doe is amongst the youngest school shooters in U.S. history, expected to discover the relative rarity of school shooters under the age of 10, inability to construct a predictive profile. Your Honor, I think all of this is immaterial and essentially asks her to assess the universe of information that's not even the universe of this case. It's saying, tell us how many other school shooters there are in this country, and that's not an issue to be decided by this jury.
all right. Defense response.
Just to respond, I would note that it is common practice. It's replete in the case law of examples of experts testifying based on their training and experience in that particular domain, that things are either uncommon, rare, occur often, or frequent. That does not run afoul of constituting irrelevant or speculative testimony regarding raw statistical data. It doesn't approach that in any respect. It also isn't something that's pure common knowledge. It is something that someone with the appropriate qualifications, training, and experience has unique knowledge about. They can testify to their experiences. Dr. Klinger is an experienced administrator, teacher. She's done this for decades. She can talk about whether or not this type of incident is rare. That happens in cases all the time. It happens in medical cases where doctors will come in and testify that these symptoms present. They are typically manifest in this type of patient presenting with these types of symptoms. It is similar here as well. This isn't beyond the scope of her expertise or credentials either. This is something where she is a trained administrator. She's dealt with kids for decades and decades. She can talk about this and explain to the jury.
All right. I'm going to find that based on her training and experience, once again, assuming that's established, that she can testify to the extremely rare nature of the incident, and that in her experience and knowledge that he's one of the youngest school shooters in U.S. history. However, I do have an issue with starting with the word inability. Actually, so let's just take that next sentence. In this regard, Dr. Klinger is expected to discuss the relative rarity of school shooters, and therefore the inability to construct a predictive profile. I'm not going to allow any of that because there's no evidence that supports why that's relevant in this case. Assuming that's what you were saying, Mr. Beniozen.
Yes, sir.
All right. So I'm going to strike that sentence. And I think the next sentence is cumulative of the first two, unless you want to be heard on that. I mean, I think we're just using the same words over and over again. So I'd say that that language is met by your first sentence.
I think there's a difference between rare and unprecedented, and they're both here.
No, she can only say it once. If she wants to say it's unprecedented and extremely rare, fine, but I'm not gonna let her say it on 2 different occasions. That understood?
Understood.
Okay. All right, anything else, Mr. Benioff?
Yes, I apologize. But the next is an issue that was specifically part of the motions in limine, where it says finally and effectively the witness is now venturing into things post January 6, 2023, and talks about how there is a difference in educational world within training of educators in the world at this stage as it relates to post 2023 incidents, and they can talk about post Richneck and these things of that nature. I think ultimately, Your Honor, there's a rule somewhat on point, which is 2407, which is the subsequent remedial measures. Obviously, this is a different situation because they're essentially proffering things that happened after the fact, but they're doing so in order to try and disprove negligence on the part of Dr. Parker by saying that since that time there are more safeguards that are put in place by school boards, there's more training about these things, and the issue there is we're going to be clouding the jury's understanding of, well, what did we know then? I mean, I thought I heard Mr. Hogan in opening statement say, you've got to ask yourself what happened then, not hindsight 2020. And now here we have this paragraph that says, let's talk about the world today.
So, that's not specifically spelled out, so I'm assuming that's referenced in the deposition testimony of Robert M. Stewart. Is that where you're pulling that?
Correct. In other words, on the second page,
What page are we on?
we're at the bottom of page 27 going on to page 28. So at the bottom of 27 it says, Dr. Stewart testified regarding post-Richneck changes in crisis management training, security in the schools, clear backpacks, weapon detection systems. In this regard, Dr. Klinger is expected to explain to the jury that in her work lecturing and consulting on school safety, after the Richneck case, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. And so the question is, well, why are we going to tell the jury about things post January 6, 2023? I understand if you want to say this is the state of the world on January 6, 2023, and this is what the educational system was like and how training was on and up to January 6, 2023, but clouding the jury's assessment of what happened after the fact. Rule 407 is kind of a shortcut to these.
Which is remedial measures.
Correct.
Okay.
So all of the rules that come after 404 are essentially shortcuts to these determinations of what is unfair prejudice and what is confusing the jury. And by rule, the Supreme Court has said that when we're talking about things subsequent to an incident and it's being offered to demonstrate negligence at the time of the incident, it is inadmissible. It may be relevant to demonstrate other things, such as control, feasibility, things of that nature. And none of those exceptions are applicable here, because what they're offering this to show is not that Dr. Parker could have or did do something differently after January 6, 2023. We know Dr. Parker wasn't at Richneck Elementary School for much longer after January 6, 2023. So these are all circumstances and actions taken by people other than her in an effort, in my view, Judge, to argue to the jury, look, had the school system done these things for us.
Which is clearly impermissible under the rule.
Correct.
Right. All right, how is this, that testimony not violative of Rule 2:407?
Judge, specifically 2407 as well as the statute, it incorporates 8.01-418.1, only prohibit the use of this type of evidence of subsequent remedial measures to prove negligence. It is silent. It does not prohibit or prescribe using that evidence to negate it. Obviously, we're not trying to establish Dr. Parker's negligence. We are negating it. That is not prohibited under this rule. Counsel is correct that this is often shorthand to try to eliminate using evidence for improper purposes. There's public policy reasons behind this. The public policy reason behind the subsequent remedial measures statute is that you don't want to deter a defendant who, after an incident or crisis that endangered folks, from taking measures to improve that, to prevent that from happening in the future. That same policy rationale is not implicated. It is non-existent where a defendant is trying to introduce those measures to negate negligence. The rule is black letter. It is very clear. It only applies to proving negligence, not negating it. Why does that matter in this case? Because evidence of subsequent remedial measures, the fact that Richneck Elementary School and other elementary schools throughout the country have implemented new safeguards in light of these types of shootings. There's a pre-Richneck and there's a post-Richneck. Pre-Richneck, these were the conditions that existed at the time. Post-Richneck, now we've got all these precautions, metal detectors, clear backpacks, all of those things. And that doesn't go to shifting blame to some other third party. It doesn't run afoul of the subsequent remedial measures statute, which only prohibits using this to prove negligence. Rather, it goes to the heart of foreseeability. A reasonable jury, viewing that evidence, can construe that had this truly been a foreseeable incident, had this been on anyone's radar, the staff, the teachers, the school district, then they would have had those precautions in place. That is legitimate evidence.
So what about his argument that it's going to negate negligence as well as basically for impeachment on the foreseeability issue, which is you did not do these things beforehand?
You did not do these things.
Yeah,
these
you
things
didn't have clear backpacks. You didn't have metal detectors, those sorts of things.
Right, and so in your question to me at this time is what about using those things in order to demonstrate foreseeability?
Correct.
The answer is we don't need to know that Richneck did those things after the fact. You can ask the question to the expert. On January 6, 2023, was there a policy at the school that required clear backpacks? No. On January 6, 2023, was there a metal detector at the school? No. You can ask the questions without the prejudicial nature of what somebody did after the fact, which is not a pertinent issue to this case.
Anything else you wanted to say?
No, Your Honor.
Either side have any case law to support their position on this one?
Not at hand, Judge.
No, Judge, I actually address this argument expressly in the defense motions eliminate or the brief in response to the plaintiff's motion to exclude expert testimony. The authorities I relied on, I did cite some authority. It was largely treatises at this point, emphasizing 22 cases, Davenport versus Utility Trader Manufacturing Company. That is 74 VA App 181, 2022 case. That is a published decision from the Court of Appeals of Virginia that is binding vertical precedent on this court. And it says that to assess whether Rule 2 or 447's general ban on subsequent remedial measures evidence applies, the court looks to two considerations. One, quote, is the evidence offered actually a remedial measure, i.e. a measure that, if taken prior to an event, would have made the event less likely to occur, end quote. And number two, quote, whether the evidence is offered to prove negligence or culpable conduct as a cause of the event, end quote. This is the plain language of the statute. The court applied that plain language. It doesn't prohibit negation.
I don't know if you're familiar with that case. I want an opportunity to respond.
I'm not, Judge, but I understand the plain language. I agree that that's the plain language of the rule. The issue here is what we're effectively asking the jury to consider is what did somebody do sometime later after the fact of January 26, 2023, and let's then use that evidence to decide an issue on January 6, 2023. And if the question is, were these things in play then? I agree, but you don't need the risk of prejudice that comes along with the question, this was implemented, or that became the educational standard, or this is how we train on things. That becomes unhelpful to the jury. If the question is only foreseeability, we don't care what's foreseeable now. We care what was foreseeable January 6, 2023, and the substantive issues of backpack this, training that. You can ask those questions without getting into what life is like post January 6, 2023.
My other concern, Mr. Hogan, is that regardless of whether or not that information comes in, you then go on to express in the disclosure that because of those factors that we've just talked about, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. I mean, do you say that that's admissible as well, based on those conclusions?
Judge, I think it'd be appropriate to excise that from the opinion.
Okay, that I agree with. All right, so now we're really just down to whether or not she can testify that since the shooting, there have been changes to crisis management, training, and security in the schools, such as clear backpacks, weapons, detection systems, etc. Is that correct?
Yes, sir.
Yes, Judge.
All right.
And that's from Mr. Stewart, a school board employee's deposition, so she's read that deposition.
And that's the basis of it. Getting back to the Mr. Rawls issue, which is if all she's doing is parroting somebody else's deposition testimony.
But can't she say that she, as part of her expertise, has reviewed that deposition and found that the school did these things? Ms. Benioff, do you have a response to that?
I'm reading the transcript.
Sure.
So I think that the second part of your sentence, that the school did these things, is the issue, because the school is not Dr. Parker necessarily. And so the implication and the purpose of the testimony is essentially to try and say, well, if only they had equipped her with clear backpacks, if only they had equipped her with metal detectors, if only they had done these things for Dr. Parker under that circumstance, then what we're doing in that instance is we're essentially pointing the finger at somebody, and we get into this empty chair issue. We're pointing the finger at somebody after the fact to try and make the job easier or different as it was on January 6th. Again, I go back to, we don't need to get into what anyone has done since January 6th, 2023. You can get to the facts of those issues by just asking what was present on January 6th, 2023. And if she knows that factually, she can testify to it. If she doesn't know it factually, which seems as though it's based within the record, she may not be able to testify to it factually if it's what Dr. Stewart testified to. She can just say, I reviewed the opinions and this is my conclusion.
Just maybe heard, there was a new argument that was raised. I won't belabor the court with argument.
All right.
The new issue that was raised was a pivot by counsel emphasizing and relying on the empty chair doctrine. Let me just emphasize that that is a red herring in this case. We are not offering this evidence to point the finger at someone else for their own liability, that they were at fault, that they should have had these safety measures in place, and therefore, because someone else is at fault, we're off the hook. That's the heart of the empty chair doctrine. It is impermissible. That is not what is happening. It is well established. It's clearly settled in Virginia. There's a distinction between that, on the one hand, pointing the finger at someone saying, because they messed up, I'm off the hook, and pointing to overlapping evidence that is similar in nature to argue that this is unforeseeable as a matter of law.
All right. I'm going to let her testify to those things exactly how we discussed it, but I'm also going to allow a limiting instruction that parrots that information, cannot be used to prove negligence, pursuant to Rule 2:407.
Or disprove negligence.
Your Honor, in how Mr. Beeninghausen suggested the questions get asked, or can she say that she reviewed the deposition?
No, she reviewed the deposition, and those are the things that she found on her review of the evidence, and then we'll give a limiting instruction that that testimony cannot be used to prove or disprove negligence.
Your Honor, she's a national school safety expert. That happened all over the country. It's pre-Richneck and post-Richneck, just like pre-Virginia Tech and post-Virginia Tech. Standards changed.
Well, then you're just talking yourself out of that testimony, right?
I'm not talking myself out of the testimony. It's the same argument. It's the argument that's in here about the pre and post standards. We just spoke about that.
They just proffered to the court that it only be offered for the issue of foreseeability of a weapon on campus. And then they've come up to say standards change on how we should judge their conduct. This demonstrates the exact issue when we have these sort of backdoor evidentiary issues, which is we're going to use it for this but not for that. And we start to get into this realm where you have an expert on the stand that says, well, the evaluator ought to do this. And he just doesn't say Dr. Watson. And so we're getting a backdoor attempt to try and address this issue as to the standard of care or negligence under the guise of a foreseeability analysis. And I'll point the court to this issue that there's foreseeability discussions throughout her designation that are not objected to. She talks about foreseeability, and we understand that she's going to talk about foreseeability. The question is whether she can say the world as it is today foresees the likelihood of a weapon on campus differently than the world saw it on January 5th, 2023, and that we don't think that that's permissible.
Judge, very briefly, the original argument was that Rule 2407 expressly prohibits this type of evidence. We just had a case, we discussed the case that says that it only operates to prohibit using that type of evidence to prove negligence. It has no operational legal effect to prohibit using that same evidence to negate it. Us arguing that this is probative of foreseeability is no different. It's in line with what is contemplated by those rules. Foreseeability is the heart of negligence. It's embedded throughout it. That's why it appears in our briefs, it appears in our pleadings, and that's why they don't object to it. This is a false distinction. This is a complete red herring, Judge. This rule doesn't operate to exclude anything. The better argument that they have is the one that they pivot to, which is that there's a Rule 2403 balancing issue here. And the case law is well established that any risk of improper bases or inferences being drawn from this type of evidence can be cured with a simple limiting instruction, which is what we'll be using throughout this case to address similar issues.
All right, I'm going to overrule the objection and allow limiting instruction.
Thank you.
All right, so what I'm going to do is I have made my notes and my marks on the original Court Exhibit F. I'm going to photocopy that for both sides so that that'll give you time to go back and talk to your witness.
And Your Honor, for planning purposes, obviously it takes a little bit of time to speak with our witness when we shift gears like this. Her testimony is probably going to take a fair amount of time. It might be a good idea to take lunch at this time, just because I don't want to get in here and then stop right away because of lunch.
Right, no, but you're not going to take, this can't be more than an hour, I would think.
We need a little bit of time to meet with her. It took a little bit of time with Dr. Hagan, as you know, just to go through the shift of gears, because these matters weren't determined at the motion and limine stage.
You have a position, please? Anyone?
I don't think we need an hour to tell a witness. You don't get to say these things.
Yeah, I'm going to photocopy it too for you. You can go and talk with her, and yeah, I want to get through her before we go to lunch.
Okay, Your Honor, that's fine, just as long as we can have a little bit of time to do that.
I'll give you 15 minutes. It shouldn't,
Yeah, that's fine, Your Honor.
Okay.
I just didn't know if you wanted to break for lunch at noon. That was my concern, or 12:30. I wasn't sure.
We got snacks for 'em.
Okay.
We, meaning the court. All right, we'll be in a 15-minute recess.
Please rise.
we are ready for the next witness. All right, may bring in the jury.
Please stand for the jurors.
And jurors in the box.
All right.
Get you to stand right here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you?
I do. If I get you to step up to this seat up here. Why don't you step out?
You may proceed.
Can you please state your name for the jury?
Sure, I am Dr. Amy Klinger.
And Dr. Klinger, what do you do for a living?
I am the Director of Programs for the Educator School Safety Network.
Can you tell the jury about your education?
Sure, I have a bachelor's degree in education as well as a teaching license. I have a master's degree in curriculum and instruction, an education specialist degree, which is in reference to educational administration, which is another master's, and then I have a doctoral degree in educational administration.
And have you held any academic positions?
Yes, I was the chair as well as the director of the Educational Leadership Program at Ashland University, and I also was a full tenured professor there.
Explain to the jury what it takes to become a professor of education and administration at a university.
Well, you have to have a doctoral degree in the field of educational administration. You have to have experience as a practicing administrator, and then you have to have a particular research area or an area of expertise that you focus on.
Do you have any certifications or license?
I have a permanent teaching license. I have a gifted validation. I have a principal's license, and I also have a superintendent's license.
And the jury's heard about something called boots on the ground experience. I'm sure you're familiar with that term. Can you tell the jury about your boots on the ground experience in a school system?
Sure. Well, I started as a teacher. Then I worked in sort of quasi-administrative roles in central office as a testing coordinator and a gifted coordinator. Then I was a principal at the elementary and secondary levels. And at the university, in a university setting, I was the supervisor for administrative interns who were out in the field. And in my current position, we work directly with schools, providing training, going into the field, being in schools, working with them to assess critical safety concerns.
And so you're still providing boots on the ground work in school systems?
Yep, I'm in schools quite often.
Okay, and that's through your School Safety Network organization, correct? Could you just tell the jury just a little bit more about what that is and how long you've had that? And
Sure.
And
I'm the co-founder of the Educator School Safety Network. We are a national nonprofit. We're a little bit unique in that we come from an educational perspective, not necessarily a security or law enforcement perspective. So we provide direct training and technical assistance and consulting to educators, both administrators as well as teachers and support staff and other school stakeholders. We also do vulnerability assessments where we help schools to determine potential vulnerabilities within the facility, but also within their protocols and procedures. We also do threat assessment training to help schools to develop threat assessment teams and to implement a threat assessment process. We also do research in the field of violent threats and incidents, and then finally we develop content. As a nonprofit, we want to be able to put resources in the hands of teachers, and so we make those available to them through some of our content development.
And have you been an instructor or a trainer for the Department of Homeland Security?
Yes, through the RDPC, I was working with FEMA and DHS to develop coursework and also as an instructor to teach it. So I co-authored the courses and then worked with other FEMA and DHS instructors to deliver them.
Have you published?
I have a book that I co-authored with my partner on school safety, and then I've also published a lot of professional journals as well as academic journals, newsletters, those sorts of things, as well as scholarly articles. And then we've also published our research. Every year we publish a research report for the previous school year.
Do you present on school safety issues, nationally or internationally?
Both. We do regional conferences, but mostly we do national ones, either related to professional organizations or related to specific topics, and when we have presented internationally as well.
Your Honor, at this time I would like to offer Dr. Amy Klinger as an expert in the field of education, administration, and school safety to testify regarding professional standards in this case.
Right, education, administration, and safety.
And school safety. School
Right.
safety, Your Honor.
Any objection?
Okay.
All right, so qualified.
Dr. Klinger, at my request, have you reviewed documents and information to determine if Dr. Parker failed to exercise any care or breached professional standards related to Ms. Zwerner on January 6, 2023?
Yes, I have.
Okay. Mr. Coleman, could you please publish to Dr. Klinger only the list of material that you reviewed? Let me know when you have it.
I have it.
Have it? Okay. So, Dr. Klinger, didn't expect you to come in here and memorize everything that I've given you, but could you just sort of educate the jury? There are different topics on the list, and you can do it by topic of what have you reviewed to give your opinions to this jury in this case.
I reviewed videos, body cam footage from the Sheriff's Department, as well as school board interviews with people that were involved in the incident. I have reviewed the discovery materials, both from the plaintiff as well as from the defendant, as well as the forensic services, the witness statements and incident reports. I've also reviewed materials related specifically to Newport News schools in terms of their operations plans, their employee handbooks, those sort of things, both for the district as well as for Richneck Elementary. I've also reviewed the depositions, all of the depositions that were taken from the various parties involved. I've reviewed the school records for the student, JT, and then in addition, I've reviewed some additional things in terms of the forensic interviews, some of the circuit court materials that involve the aspects of the mom.
Okay. In a moment, we're going to get into your opinions. Before we do you agree to express only opinions you hold to a reasonable degree of educational and professional probability?
I do.
And having reviewed the materials, have you formed opinions regarding whether Dr. Parker failed to exercise any care or breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I have.
And before we get to those, I just want to make sure the jury understands. Were you retained to help educate the jury about the issues in this case? Is that your understanding?
Yes.
And as an expert in school administration and school safety, have you reviewed cases for lawyers before?
Yes, I have.
And approximately how many cases have you reviewed as an expert witness?
About 25. This isn't my full-time job. I have my work at the Educator School Safety Network, but I've done about 25 cases.
And do you agree to accept cases both for and against school administrators?
Yeah. Actually, the majority of the time I am working on behalf of the plaintiff, not the school.
And this is your first time testifying in front of a jury, isn't it?
It is.
Not your first time presenting, but your first time testifying in
Yes.
front of a jury. Since providing expert services takes away from your work in the school safety arena, do you charge for your time to review cases?
Yes, I do.
And how much do you charge to review records?
$350 an hour.
And how much are you charging to be here today to testify in court?
$500 an hour.
And have you ever met Dr. Parker?
No, I have not.
Now we'll get to your opinions. Dr. Klinger, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She did not.
And Dr. Parker, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker was indifferent to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She was not.
Dr. Klinger, I'd like for you to, if you can help me, educate the jury about the roles and responsibilities of an assistant principal. Could you describe for the jury the roles and responsibilities of an assistant principal in an elementary school?
Sure. It is just that, to assist, working with the principal, but also working with the staff. It is a very collaborative role. It is working in all aspects of school operation, the instructional program, the staff relations, the professional development of staff, the daily operations and management, including safety, as well as the operational community relations side of things, working with parents, working with students, student discipline, special education. Very similar to that of a principal, but in this particular case and in most job descriptions for an assistant principal, it says assist with. So it is very much an assistance collaborative sort of role.
Now, is school safety an area that the assistant principal assists with?
Definitely, yes.
Now, is an assistant principal the sole person responsible in a school for school safety?
Oh, absolutely not. No one is the sole person responsible for school safety. School safety is a collaborative endeavor. Every person who is in that organization has roles and responsibilities related to safety. Every single person, every staff member, students, administration, everyone that you would consider a school stakeholder has a very critical role in school safety, as well as responsibilities related to those roles.
And what is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or a potential threat in the school?
I'm sorry, can you say that again?
What is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or potential threat? What do they do first?
Well, they need to establish the credibility of the threat, and that is not something that can be done alone. That's where the collaboration that I'm talking about. It's really important for an administrator to get feedback and information and disclosures from the people who are closest to the event. A school administrator cannot be everywhere. They cannot see everything. School incidents, school safety concerns do not occur in a vacuum. The world continues to spin. Other things continue to happen. The school day progresses. So it may seem easy to go, well, here's one thing. We need to do that. But school administration is sort of spinning plates where you have a lot of different things going on and you need to be able to prioritize. And one way to do that is to get input from the staff, to get good information to assess the plausibility, the specificity of the threat, to look at the circumstances surrounding it, and to get good intelligence, if you will, from boots on the ground.
Okay. And who does the assistant principal look to get the primary information?
You look to the people closest to the event. 911 operators and emergency responders will tell you they want to talk to the person closest to the event. They want to talk to the person directly involved. And in this case, those people had the potential to be really good resources. You had Ms. Kovac, who was a veteran teacher who had an established relationship with the student, who had worked with that student on a quite frequent basis. You had Ms. Zwerner, who was in the classroom, knew the student, had the student every day, had eyes on the student, what the demeanor was, what the context was, what the behaviors were. You had Mr. Rawls, who had extensive experience working with troubled students, working with students who may act out in some fashion. And so all of those people are valuable resources that can provide information to assist in evaluating the nature of a potential school safety concern.
And are teachers and people in the immediate area something called first-line responders? Is that a term that's used sometimes?
Yes, and they're first-line responders. They are the people that can see it, that are experiencing it, that can provide context, a really critical context of what was said, what was the demeanor, how was the person acting, what did other people say, what sort of actions are being taken. And so those first-line people provide really important intelligence for an administrator to evaluate the credibility and the appropriate course of action for response.
And does every school safety concern require an immediate aggressive response from a school administrator?
School safety concerns require an appropriate response from an administrator in the sense that it does not necessarily have to be immediate, it does not necessarily have to be aggressive, and sometimes that can be counterproductive. So if you think about the feasibility of every time a person discloses something, that we go to the nth degree and we're going to immediately lock down or we're going to immediately do some dramatic response, you would never have school. You would be clearing classrooms all day long. It would be impossible for a school to function. On the other hand, school administrators have a responsibility to balance those things, to be able to get intelligence and information and make informed decisions about what the most appropriate course of action. Because think of the nature of a school where everyone runs around totally in crisis all the time because every threat is being treated exactly the same and we're going to DEFCON 5 on every single threat. That's not safety. That is constant panic. And it also actually can make the school less safe because people become numb to it. You get into a boy who cried wolf situation where people are going, it's just another one of those, it's just another one of those. So the appropriate response, a measured, appropriate analysis of the information and the situation is really critical to keep people safe.
And Dr. Klinger, can you tell the jury the factors that an assistant principal must rely on to assess the potential severity of a reported student behavioral issue?
Well, in terms of looking at trying to establish or analyze the potential problem, plausibility is a big one. How plausible is it that this thing could be occurring. And that really factors into the age. I mean, in this particular case, if you're discussing a potential weapon or something of concern at high school or a middle school level, it is much more plausible that there is the potential there that a weapon could be present. When you're discussing the plausibility of a 6-year-old having access and ability to bring a weapon to school, clearly we know at that point it was unprecedented and certainly not as plausible as you would find. So clearly that's one issue. Specificity is another, of how specific is the threat, what exactly is being said, what exactly is being disclosed, what words, what terms are being used. And then there's the context surrounding it. And again, threat assessment teaches us that we need to have the context of in what manner, under what situation, what were the circumstances. All of that kind of information is really critical, and an administrator cannot get that because they're not a mind reader. They are not clairvoyant. They cannot be everywhere. The way to get that is to get that information from the people that are seeing it, experiencing it, talking about it, and getting those reports and being able to aggregate that information so you can look at how specific is this, how plausible is it, what's the context, how credible, how severe. And all of those things have to be taken into account in order to be able to have an appropriate response.
And you talked about the assistant principal assisting with a lot. Is the assistant principal in this role triaging information?
Yeah, it's very important to be able to, because again, as I said, this doesn't occur in a vacuum. So because an administrator cannot do everything, they have to rely on the capacities and the skills and the professional judgment and the input and the context from other staff members and other people with which they work. So it's really trying to aggregate those things together, because you cannot make a decision totally and completely by yourself.
In your review of the material, you've told the jury what you've reviewed. Were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern on January 6th?
I think it's an improper opinion, Your Honor, not an issue in this case as it relates to Ms. Kovac, and for the reasons I stated previously.
Can you ask your question again?
In reviewing the material, were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern?
I'm going to overrule that.
Go ahead.
Well, Ms. Kovac was present when Ms. Zwerner indicated initially about some defiant behavior. Ms. Kovac was told by some students that there was a concern about JT.
Don't say anything Ms. Kovac was told, but or just what your understanding of what action she took based on what she.
Based on the review of the materials.
Sorry, so yeah, you can't tell us what other people said, just that you relied on that information.
So based on the review of the materials, information was given that there was a concern. Ms. Kovac did not go to Dr. Parker. She did not call a lockdown. She did not call security. She instead went to investigate and spoke with the student or interacted with the student. When the student did not reveal the book bag, did not allow for the book bag to be looked at, Ms. Kovac did not call a lockdown. She did not remove the book bag. She did not remove the student. She did not remove the other students. She stayed in the classroom, and after a lesson left the classroom then to report to Dr. Parker that the book bag had not been looked at. She went to lunch, the students went to recess, she came back during recess to look at the book bag. She did not call a lockdown, she didn't call security, she didn't call Mr. Rawls.
We're just reciting the experiences of Ms. Kovac from the day. I don't think it's responsive to any particular question. And the only foundation this witness would have of any of this information is in fact hearsay.
Well, she's stating from her review of the records, and that's what we're allowing her to testify to, so I'm going to overrule that. You may continue.
After it was disclosed to Ms. Kovac that the item had potentially been moved from the book bag, she observed the student at recess. And when the student did not approach her, wouldn't come up to her, and was acting in a manner that could be perceived as suspicious, she did not remove the student, she didn't move the other students, she didn't disclose immediately all that information to Dr. Parker, she did not bring security in, she did not respond in a way that would indicate there was an urgent or imminent problem at that point, and then returned to her work in testing.
In any of the material that you reviewed, did you see any information that indicated Ms. Kovac thought it was a toy gun?
Objection, Your Honor.
Ask the question again.
In reviewing the material, did you see any indication, and you've read the statements and whatnot, that there was a thought that it was just a toy gun, this 6-year-old?
Your Honor, I'll proffer, and I think counsel would proffer, the only basis would be a statement which you ruled was inadmissible. Backdoor.
All right, I'm going to sustain that objection based on a previous ruling.
Do you want to tell the jury anything else about what you observed or from the records about Ms. Kovac's actions that day? I didn't want to cut you off.
No, just that testing resumed. She resumed her job responsibilities, and she was the person that had that relationship with JT.
And in reviewing the material, were there any actions taken by Ms. Zwerner indicating there was not a significant level of concern?
Ms. Zwerner reported to Dr. Parker going to lunch, and then, based on my review of the materials, never spoke with Dr. Parker again. There are numerous disclosures or information in the materials that indicates she was given information from students about a concern that
Objection, Your Honor. This is exactly what you ruled upon.
Do you have a response?
We can move on from that. Just
Fine.
talk about the actions of Ms. Zwerner with respect to what you understand from the material with respect to what was going on in the classroom and whatnot, and going to play to the...
That's to be stricken. It's sustained.
All right, I'm sorry, was that her moving on, or
The
the
statements
last
before,
statement?
the last statements that were objected to, if it's
All right.
sustained.
Yeah, they're stricken from the record, just like we talked about. If I strike something, you can't consider it. All right, go ahead and ask your next question.
Dr. Klinger, what is the material that you've reviewed? What actions did Ms. Zwerner take in the classroom once receiving information from Ms. Kovac about what other students were saying?
Well, instruction went on. The student remained in the classroom. Even though previously the materials indicate that security had been called in the past, that Mr. Rawls had been asked to assist in the past, none of that assistance was requested. No reports were made to Dr. Parker. The school day went on. The student went to recess. The first grade teachers, one of whom was Ms. Zwerner, observed the student, reported suspicious behavior to each other or texting it to Ms. Kovac, did not report that to Dr. Parker, did not clear the playground, did not remove the student, did not take the book bag, did not remove the other students. And so there's a lot of different opportunities for, and a lot of resources available for assistance that we know were employed in the past.
And did you see any actions taken by Ms. West indicating that she did not feel that it was a significant level of concern?
Objection, Your Honor, as to what you felt.
Sustain that.
Or indicated that there was not a significant level of concern? Same question I'd asked before.
Same objection before. I think the Freudian slip indicates what is being intended for.
Well, obviously, I'll disregard the previous recitation of that question and allow the second one.
I'm asking it the same way I did before with Ms. Zwerner, indicating that, did you see in the material any actions taken by Ms. West indicating there was not a significant level of concern?
Ms. West took a student, a different student who had a disciplinary behavioral issue, to Dr. Parker during recess, and did not make any discussion of what was observed at recess, the suspicious behavior, those different behaviors that were being observed at that point. She asked Ms. Zwerner to watch her class and bring them in, so that doubled the size of the number of students that Ms. Zwerner was supposed to be supervising, which would indicate she felt that was appropriate to do, to ask her to do that.
Objection, Your Honor. Same thing.
All right. Overruled. Continue.
Anything else
No.
with Ms. West? Did you, in your material that you reviewed, you read the deposition testimony, see anything to indicate that Ms. West actually encountered Dr. Parker in the building?
She brought a student to, a different student that had disciplinary concerns, to Dr. Parker, and was involved in a face-to-face discussion with her, but that discussion did not include any disclosures about the behaviors of JT at recess.
And is that something you would have expected if there was a significant level of concern, that there had been a discussion at that time?
Yeah, I think it's important that this was an evolving situation, and one critical element is to get updates on what's happening, what's going on, what has changed, if anything, and those updates were not occurring.
And same with Mr. Rawls. So you've read all the deposition testimony and the statements of Mr. Rawls and whatnot. And is there anything, any actions taken by Mr. Rawls indicating that there was not a significant level of concern?
When Mr. Rawls spoke with the student R after recess, he received information, more information about JT, and again, did not feel that it was necessary
Objection,
to,
Your Honor. Did not feel.
sorry,
You could just say what he did not do.
he did not remove the student, he did not clear the classroom, he did not call security, call for assistance, call a lockdown. All of those things are capabilities and resources that were present to any of these individuals.
And in the material review, did you see that at some point there was a discussion between Dr. Parker and Mr. Rawls about body searching the student? And do you have, what is your understanding about decisions made in that regard?
Generally, or in this specific?
In this specific case?
There
Without
was
saying what someone said.
There was a discussion about an option for a search of the student, and the approach was cautious, as it would be appropriate to do so. And there was a determination made that when the parent was present, that search could continue.
Okay. And why would it be, in your experience, that a search of a student is something that could be cautious if you're looking for a weapon?
Well, we should always be concerned about the search of a student, regardless of their age. But certainly, and that is not something that any school administrator should enter into lightly. But I think it's really important to think about, this is a 6-year-old, this is a little kid, and we are going to do, just at will start doing body searches on kids. That's not any kind of endeavor that anyone should do, especially when they don't have a good amount of intelligence or information that would support that at that point.
Dr. Klinger, do you have any opinion on whether Dr. Parker could have foreseen JT's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that. I think the actions of everyone involved indicate that they were doing an analysis, but yet that they did not perceive this to be a plausible, imminent threat, both the behaviors as well as the actions, because it is a 6-year-old having access to a weapon and bringing it to school, and it is largely unthinkable and certainly unprecedented in terms of the outcome.
And Dr. Klinger, did you review any protocols of the Newport News school system in your review of the materials?
The crisis plan for Newport News, yes.
And did your review of any protocol change your opinions in the case in any way about assessing the threat or the school safety concern?
No, the protocols of a crisis plan provide a framework. They provide guidelines for what people should be doing. But they also have to, and in this particular case, they give people latitude for professional judgment. When a crisis plan becomes so prescriptive that you must do this, you must do this, you must do this, it really makes it actually more ineffective. So it is critical that people have the ability to use the tools that we've talked about and that use the judgment that we've talked about and incorporate or factor in the circumstances that we've talked about when they're making that decision.
And Dr. Klinger, are all of your opinions and conclusions you've provided to the jury today held within a reasonable degree of educational and professional probability?
Yes.
Please answer any questions Mr. Beniozen has.
Cross-examination?
Yes, Your Honor.
No, object. It's another roadmap. Object.
You can have roadmaps for your witnesses, but not for theirs.
All right. Good afternoon.
Hi.
We're going to talk about 3 things, okay? We're going to talk about getting good information. We're going to talk about the threat. And then we're going to talk about over-under, okay? You understand what that term over-under means?
Mm-hmm.
And in your report, you talk about overreactions and underreactions. Is that correct?
Yes.
And it's also a term used in the gambling world, over-under.
Can't speak to that, but yes.
All right, so let's take it one by one. Let's start with getting good information. You talked about in direct how teachers are first-line responders, true?
Teachers and support staff.
First line,
Yes.
which means that there's a second line.
Mm-hmm.
Is that right?
Yes.
Second line being the assistant principal, true?
Well, it depends on the hierarchy of the school. I mean, some schools don't have assistant principals, but if you want to say administration globally, yes.
And in this case, Richneck did have an assistant principal, true? And that assistant principal was Dr. Ebony Parker.
Correct.
And you mentioned before about getting good information and how first line responders are closest to the information. Is that correct?
Yes.
And on this day, it sounds like you're critiquing the information that was passed along to Dr. Parker. Am I interpreting your testimony correctly, that you're critiquing what people shared with Dr. Parker?
Well, I think the nature of what is shared is relevant and important to it. I mean, we have to understand this is a tragic, horrific event for every single person involved. So critique may not be the word, but I think clearly we have to evaluate the nature of the information that was given to her.
Right. And getting good information is a two-way street. Fair? Mm-hmm. Is that yes?
Yes, I'm sorry. Yeah, I know. I should know better. Sorry.
In other words, you don't think an assistant principal should just sit in their armchair, wait for people to tell them information, and then just decide what to do based on what they tell them, right?
I don't know that that's what happened in this case, because there were other instances going on. There were when Ms. West brought her student, and then sometime in the afternoon cried out for help, and Dr. Parker came because two students were fighting in the hallway. So I wouldn't say that she never got out of her chair, because clearly she provided assistance when it was asked for.
Okay, so let's take it step by step.
Okay.
You agree that an assistant principal can't just sit in their chair and wait for information to come to them, true?
I think that an assistant principal can have a reasonable expectation that if there's something she needs to know, people will tell her.
Okay. And so she should just assume everything's okay unless somebody comes and tells her more.
Well, your option then is that you have to go door to door and ask everybody, hey, is everything okay here? Is there anything I should know? Is there anything? And that's not really feasible for the management of the school.
Really happy you said that, actually. Really happy you said that. So let's talk about going door to door. In this context, Ms. Kovac told Dr. Parker explicitly about a gun and a specific student, true?
At what point?
Around noon.
Prior to going to lunch?
Correct, around noon.
There was a discussion of a weapon.
It wasn't a gun in his book bag.
That's not what you asked me. You asked me what she told.
Right, that's at noon, around noon. Did Ms. Kovac go into Dr. Ebony Parker's office and report that students were saying that JT had a gun in his book bag?
My understanding in the review of the materials is that she said that the students reported he had a weapon.
And your review of the materials, I hope, included the written statement of Dr. Parker? Mm-hmm. Is that a yes?
Yes.
Okay. So I'm going to go ahead and show you that. It's been pre-marked as Plaintiff's Exhibit 2, Your Honor. You were provided this written statement written by Dr. Ebony Parker.
Yes.
Has her name on the bottom there. Do you see that?
Correct.
Permission to publish, Your Honor.
Any objection?
Just 1 second.
Yep.
Objection?
All right, no objection. I'm sorry, you said no objection, correct?
No objection.
Okay, thank you.
Your Honor, I'm just double checking that there aren't any references to the child's full name.
It does have the child's name in it, so
What's that?
it has the child's name and it has.
All right, so we'll block that.
Permission to publish, Your Honor. Thank you. So, in the materials that you were provided, Dr. Klinger, this is the sentence I was reading to you. At around noon, Ms. Kovac came into my office and reported that the students were saying the student, JT, had a gun in his book bag. Do you see that? Mm-hmm. Is that a yes?
Yes.
And so, when you said earlier, you can't go around every classroom, knocking on every door, searching every bag. You recall that testimony?
Well, I was speaking in terms, your question was about finding out if everything was okay. It wasn't about searching bags.
Okay. Well, in this case, there was a specific child reported to have had a gun in his book bag. True?
Yes.
And because communication is a two-way street and getting in good information is a two-way street, you would expect the assistant principal to attempt to get some information herself. True?
Well, according to that statement and the materials that I read, there was a discussion between Ms. Kovac, who was a seasoned educator with a relationship with the student, third in line in the chain of command. There was a discussion between her and Dr. Parker, and Ms. Kovac indicated she was going to go and look in the book bag.
And based upon the information that you received, that she checked the book bag, there was nothing in the book bag, but that there was a report that there was something put in his pocket. True?
That was a report made later, yes.
And you're familiar that in response, Dr. Parker observed that the child's pockets were too little. True?
That's in the materials that's alleged.
And so when we're talking about getting good information, to make sure that we're on the same page regarding good information, when we talk about Miss West and Miss West bringing a child to Dr. Parker, do you recall your previous testimony about that?
She brought him to the office, yes.
In fact, according to Dr. Parker left her office and went and retrieved the child. True?
Which child are we speaking of?
The one that was eloping.
Yes.
So Dr. Parker at some point in time did decide, I'm going to leave my chair and I'm going to go deal with a student.
Yes. I believe she also left her chair when the students had the altercation in the hallway, and also to talk with Miss West about the student she brought in from the playground.
And during those times in which Dr. Parker left her chair, did she go and inquire with the student JT?
Specifically to the student,
Yes.
JT, or about the student?
To the student JT?
No.
And you mentioned about how when law enforcement gets phone calls on dispatch, they always want to get information straight from the source. Do you recall that? Mm-hmm. Yes?
Yes.
And when we talk about getting information straight from the source, in this context, there were two girls who reported to Ms. Kovac who reported to Dr. Parker, true?
Yes.
And at what point in the day did Dr. Parker leave her desk to go talk to girl number one?
Well, in her testimony, Ms. Kovac indicates she didn't know who they were.
Not my question. At what point in the day did Dr. Parker leave her desk to go talk to girl number one?
How could she if she doesn't know who girl number one is? Because Ms. Kovac doesn't know who girl number one is because she didn't ask her name and didn't get the information, which makes it difficult to investigate
So
if you don't know who the student is.
So Dr. Parker's obligation there stops because she doesn't get good information, so she can sit back and just rely upon the fact that she didn't get good information.
That's not what I said. I said it would be difficult to interview a student that you don't know who that student is.
You mentioned earlier that there are, 40 first grade students? And 20 in Ms. Warner's class?
I
20
never said how many students there were.
She didn't testify.
Earlier you had
Okay,
talked.
wait, hold on, gotta sustain that objection, rephrase.
Earlier you had talked about how at some point in time one of the teachers was looking after two classroom sets of students, true?
Correct. I said Ms. Zwerner had double the students. I didn't say a number.
Okay. And so, just so we're on the same page, Dr. Parker never went and attempted to talk to a girl or two girls, true?
The ones that disclosed to Ms. Kovac you're speaking of?
Yes.
She did not because she didn't know their identity.
You say because she didn't know her identity. You've never spoken to Dr. Parker, have you?
No, I have not.
Okay, so when you're trying to say what Dr. Parker knew or didn't know, it's conjecture. You don't. She's never told you she didn't know the identity.
Well, the materials say that Ms. Kovac did not.
But
So I don't know how Dr. Parker would be able to know who Ms. Kovac spoke with if she didn't see her speaking with the two students and Mrs. Kovac didn't know the name of the two students. I don't know how Dr. Parker would know that, but you're right, I don't know that.
Okay, so you do not know whether Dr. Parker knew or did not know.
I do know that Ms. Kovac did not know the names of those students, and she didn't inquire or bring them to Dr. Parker so that Dr. Parker could speak to them.
Dr. Klinger, I know this is your first time in the courtroom. Just asking that you answer my questions. I'll be happy to let you expand, but I just want to make sure that we're not talking past each other.
Most certainly.
So, you do not know, because Dr. Parker never communicated to you, whether she knew or didn't know who those two girls were.
That is correct.
And when we go further and talk about getting good information, at some point in time when it's reported to Dr. Parker that there's a belief that there's something in his pocket, we talked about that a moment ago, correct?
Correct.
At that point in time, you'd agree that there's still at least a possibility that there's a firearm on campus, true?
Yes.
And at that point in time, to address the possibility of a firearm, did Dr. Parker request any specific information from anybody to be conveyed to her?
Specific information from anyone?
Correct. Did she say, will you go and search the person? Or will you go and talk to JT? Or why don't I go and talk to JT? Did she request any specific information in order to make the decision of what to do about a possible firearm on campus?
In the review of the materials, it would appear that that was a discussion that was had with Ms. Kovac and also with Mr. Rawls.
But that was, so let's get our timeline right. Ms. Kovac looks at the book bag, no gun in the book bag. They go and talk. That's when the comment is about little pockets, right?
Yes.
And that's about 12:20 in the afternoon, true?
I don't have a timestamp on that, so I can't speak to that.
And then Mr. Rawls comes and talks to her at 1:40 in the afternoon. Isn't that correct?
Again, that's my understanding, but some of the times seem to be a little contradictory in my review of the materials. Some of the times, depending on the statements, were a little bit off, so I don't want to say 1:40 with certainty.
Let's say it was 1:40.
It was after recess.
Let's say it was 1:40. That would mean that for about an hour, Dr. Parker was aware that there was the possibility of a firearm on campus at Richneck Elementary, true?
That there was the possibility that JT had what students were characterizing as a weapon and a gun.
Is that different than what I had asked you?
Yes, you said firearm. Typically, students would not disclose a firearm. They would say a gun, meaning a squirt gun, a gun, meaning a Nerf gun, a gun, meaning bullets. Again, in my experience, students, I'm sure there are some, but very young elementary students don't typically use technical terms like firearms and things like that.
But we just looked at the report from Miss Parker herself, Dr. Parker, Exhibit 2, and it used the word gun.
Yes.
Okay.
I'm not disputing that.
And it didn't say toy gun, true?
The students
This-
said gun, yes.
And this report from Dr. Parker used the word gun, not toy gun, true?
That's what said the report says, yes.
Okay. And so, let's talk about the threat at that point. You mentioned earlier about this isn't something that would be foreseeable. Do you recall that?
Yes.
Your Honor, I'd like to, just for demonstrative purposes, it's just a scale.
Object, Your Honor.
I can't see what that is. Okay, I'm not exactly clear where you're going with that.
Object, Your Honor. It's another diagram drawn by Mr. Beniozen during trial.
I don't know where he's going yet. Continuing objection until we see where it's going.
You mentioned not foreseeable, correct?
Yes.
All right. As of, don't publish this yet, please. At that point in time, we're talking well, let's actually start before. January 6th in the morning, before JT comes to school. What, in your expert opinion on the issue of foreseeability, what was the foreseeability of a gun on campus at Richneck Elementary School on a scale of 0 to 10?
Incorporating all students, K through 5?
Yes.
So every student there.
What was the foreseeability of a gun on campus? 0 to 10.
Inclusive of the entire population of the school?
Yes.
Probably a 1.
So it's not like it's off the radar, true?
Correct. Now, if you want, well, I can't tell you what to ask me, but that's why I ask about the number of students. The younger they go, the younger they are, the lower that number would be.
Okay, but when we talk about a firearm on campus, we're talking about a risk, a threat, true?
Yes.
And that's because a firearm on campus at an elementary school isn't just a risk of an active shooter. You'd agree with that, right?
Yes.
There's a risk of an accidental shooting, correct?
Yes.
And so any firearm on campus is a threat, true?
Yes.
And so on a scale of 1 to 10 before January 6th, it's a 1, true?
Before January 6th?
Yeah.
I thought you said that morning
the
of.
morning of.
I thought.
That's what I mean.
Okay. Yes.
And overrule the objection. You're using this for demonstrative purposes only.
Yes, Judge.
You may proceed.
Go ahead. and you tell me if I'm misstating, okay? Say foreseeability of gun on campus. Is that right?
In a K-5 environment, correct? You're asking me? Yeah,
Is that correct?
that's correct.
And we agreed that this equals a threat, at least some threat.
The foreseeability
A gun
equals a
on
threat?
A gun on campus.
The gun equals a threat, yes.
Okay, and so we're at a 1. True?
Based on what you described to me, yes.
So we'll call it 9 a.m. 1/6/23. So, you're familiar with the Richneck handbook, correct?
Yes,
And you're familiar that the Richneck handbook actually contemplates a level 3 incident involving the possession of a firearm, true?
yes.
How does that change your determination of foreseeability? Does that make it more foreseeable because they've thought about it in the manual that it could happen, or does it make it less foreseeable?
I'm sorry, I don't mean to, I'm not sure that I understand what you're asking me.
Sure. In the context of Richneck Elementary specifically, there is a handbook that calls a Tier 3 threat assessment, and that is if there's a possession of a weapon. Do you recall that?
Yes, I believe that's for the whole district, though, not just specifically for Richneck. Is that correct? Your understanding as well?
And Your Honor, if he's gonna question her, you can show it to her.
Have to show it to her.
Have, show her, publish it to her, I'm not sure it's in evidence, but.
You can show her, yeah,
Okay.
just don't publish it.
This is already in evidence as
Okay,
exhibit
if it already is the
108.
one that is,
So this is permission to publish?
yeah, if you can just read the exhibit number on there.
This is exhibit 108. You see the Richneck Elementary School staff handbook,
Yes, I do.
and section 3, we talk about level behaviors. Get into it. There's a specific discussion of a possession of a weapon. Do you see that?
Yeah, can you slide that down so that I can't see all of what the title, there you go, thank you. see it now.
Possession of a firearm, or weapon, excuse me.
Yes, those being behaviors that need to be immediately reported to an administrator.
Understood. And in this context, in light of Richneck Elementary's specific understanding that that is a student behavior, how does that increase or decrease your foreseeability analysis? Does it make it more or less likely, in your view, that there's a gun on campus if they've already talked about the possibility of a gun on campus?
No, I would say that most likely that's part of a larger comprehensive plan that was supposed to be appropriate for all levels, including secondary levels. And also, this is a K-5 building, it's not a pre-K, so you have older students in the building as well.
Understood. So then let's talk about 1 through 10. When Kovac tells Parker, gun, it was a 1 at 9 o'clock in the morning. What is it at the time that Kovac tells Parker there's a gun?
Well, it's higher than a 1 because you have that word that's being used, but there also is the plausibility factor, the factor of what the student said. Unfortunately, there were no statements taken specifically from the students.
Dr. Parker didn't take any statements.
Right, so we don't know who the students are. We
Right.
don't know. So we only have what Ms. Kovac relates. So she relates, or Dr. Parker relates, that they use the word gun.
So 1 out of 10, higher than a 1. What is it?
Yes. At this point, I would say, given the fact that Ms. Zwerner had just been there and indicated that JT was being defiant, but did not indicate that he was acting strange around his book bag, or that he was showing things to kids, or that kids were frightened, or any of those things, it's probably a 2 or a 3 at this point.
Okay. Then we have a moment in time, as we talked about, where Kovac says, no gun in backpack, put something in pocket. Is that right? Is that true?
We have a moment where Ms. Kovac has looked in the backpack and there is no gun, and Ms. Zwerner has texted Ms. Kovac and told her that he put something in his pocket. Dr. Parker did not know that until Ms. Kovac told her.
Right, so that's the moment I'm talking about. The moment where Kovac says, no gun in the backpack, but there's a report that he put something in his pocket. This little pockets moment. You understand where I am in the timeline?
Yes, I do.
Scale of 1 to 10. What's the foreseeability?
I think we're still basically in the 2 to 3. And actually thinking of the size of an actual firearm.
You're still at a 2 to 3.
Yeah.
All right.
And may I qualify what or clarify what you're saying? You're saying based purely on this information, not all the other information that was observed by other people that was not disclosed to Dr. Parker, is that correct?
Well, ultimately, we're asking, and the question in this case, as you understand it, is Dr. Parker's actions, correct?
Right, but
Yes.
you're asking me to give you this numerical judgment based on purely the information you're writing on the paper, correct?
Well, yes, if
Okay.
there's something more that you think should be considered, you're happy to tell. I'm welcome it.
Mm-hmm.
When you said earlier, it's unprecedented and it's not foreseeable, I'm trying to get an understanding of how these different pieces of information may affect that.
Sure.
Is that fair?
Yeah.
Okay. So we're at a 2 to 3 still after the conversation about something in the pocket. Then the next discussion, as I recall it, and you tell me if I'm wrong, the next discussion is when there is a question from Mr. Sims to Dr. Parker about, did we search the person? Am I correct?
Yes.
Okay. And so we talked about context clues, essentially. You know, we have to read into the conduct of staff members to get an indication of how credible a threat is. Do you recall that testimony in your direct?
No, that's not what I said. I said context, not context clues.
Oh, okay.
Well, I'm just saying it's not the same thing.
Okay, so we'll talk about context. At this point in time, when Mr. Sims comes to Dr. Parker, there's still a possibility of a gun on campus, true?
The possibility, yes.
A 2 to 3 possibility.
Yes.
And Mr. Sims is now saying, have you searched the person, true?
To Dr. Parker?
Yes.
Yes.
Okay. And so at that point in time, when Mr. Sims is asking, did you search JT, how does that affect the foreseeability? I mean, it's a teacher saying, hey, we need to check the kid.
Well, I believe Mr. Sims was relating information. I think he was covering the office at the time. So I believe he was more of an intermediary than a person urgently raising a concern, but that may be up for interpretation. But he does, you're asking me, did he speak to Dr. Parker about that? Did he ask that? Or what? Maybe you can ask me again with that caveat.
Sure. When Mr. Sims goes to Dr. Parker and says, did you search the person, in light of the fact that there is still a possibility of a gun on campus, what is the foreseeability at that point in time in your expert opinion? 2 to 3, more than 2 to 3, less than 2 to 3?
Well, it's easy now to go, boy, we should, but in that context, with the fact it's a 6-year-old, with the fact that Dr. Parker is not privy to all of the subtleties and the context that you alluded to, and given the fact that now we are looking for something, one student R indicates bullets, and so we now haven't really elevated that a great deal.
So 2 to 3?
Yeah. I mean, if we wanted to do a parallel exercise where we were talking about a high school student or a middle school student, clearly we would be talking different things, but I'm answering your questions specifically for an elementary, kindergarten, 6-year-old.
I know you're saying that, and that's this idea that a high school student may more intentionally fire a gun. Is that fair?
I'm saying a high school student most likely would have greater access to a gun, would have capabilities to use it, would have the capability or the forethought to bring it for threatening purposes, which might speak to your concern about safety. I mean, if we want to just go statistically, how many 6-year-olds have you seen walking around with a gun versus how many 17-year-olds have you heard having a firearm?
If you want to talk statistically, we can talk about the CDC's investigation into accidental shootings in elementary school students in 2023. Did you review that finding of the CDC?
For this case? No.
Okay. You are aware, because you work with the Department of Homeland Security, that the CDC did perform an investigation into the prevalence of accidental shootings in minors, specifically children of the age of JT, correct? You're aware of that as an expert, aren't you?
Aware of that study or aware of it in this context? I did not review it for this case, and this was not, you were asking me questions not about an accidental shooting, you were asking me about foreseeability.
Foreseeability of a threat on campus.
Yes.
If there is a gun, true?
Yes.
And whenever there's a gun, especially at an elementary school, an accidental shooting is a threat, true?
Yes.
And so, at the time that Mr. Sims goes and talks to Dr. Parker and is continuing to ask about a search of the person, it's still, in your view, it's a 2 to 3 foreseeability of a threat at that time.
For a 6-year-old,
Just asking you about a gun on campus. 2 to 3, more, less.
well, I think you're asking me to make a unilateral statement, and I'm trying to provide the context that you referred to. And the context being the foreseeability of a 6-year-old having a firearm.
So it's okay to just disbelieve it because
That's not
what are
what I
the
said.
odds?
You're asking me about foreseeability. You didn't ask me about response. You didn't ask me about attitude. You asked me about foreseeability.
We'll get there.
So foreseeability of a 6-year-old is in the low end of your scale.
Okay. So we're at a 2 to 3.
Yes.
After Mr. Sims leaves Dr. Parker's office, there is then another conversation with Mr. Rawls, correct?
Yes.
And this is the conversation I think that you and Mr. Rawls during that requests, oh, that's really bad, requests to search, true?
Who are you referring that Mr. Rawls is talking to? You're done with Mr. Sims, right? You're talking with Dr. Parker, correct?
Correct.
I just want to be clear so I can answer it correctly.
So Mr. Rawls requests to Dr. Parker to search the student, true?
There is a discussion about searching.
Okay.
Yes.
And that's now the second discussion about searching the student. Mr. Sims, then Mr. Rawls, true?
The first one was a informational, has he been searched? This one was a discussion about searching.
And, okay. And so, at this point in time, foreseeability, 2 out of 3, more, less?
Well, I think you're equating the discussion of searching with somehow urgency or more likelihood. So I don't see that there is a, again, significantly higher likelihood. It is still quite implausible, even though we know it happened. It is still not a lot of specific information. It's still all the things that we talked about. So yeah, we're still in the lower end. I think Dr. Parker and Mr. Rawls' discussion centered on the plausibility, but also on the caution through which an administrator should undertake a body search of a 6-year-old. And so there wasn't a refusal to search. There was the decision that it needed to be done with parent, not necessarily permission, but parent involvement.
So 2 to 3, or is it more?
I don't think it goes up a lot more, no. And especially considering that Mr. Rawls has experience with
it go up at all?
troubled students.
Objection, Your Honor, he's cutting her off.
A minute. I just asked more than 2 to 3.
All right, so we can answer his question.
Is it more than 2 to 3? You said not much more. How
No.
much more?
3, there.
3. All right. We moved a little. And you're talking about this communication process with the assistant principal, Dr. Parker, and the staff members, correct?
Yes.
And in your book titled "Keep Students Safe Every Day," that's the title, correct?
No, it's keeping students safe every day.
Sorry, I missed the ing. You'd agree that a crisis event occurs in a school, there needs to be effective communication, correct?
That is correct.
And that the assistant principal is the leader in that regard, correct?
I don't say that in the book. The assistant principal is the leader in that regard?
Do you?
I don't remember writing that.
All right. Is the assistant principal a school leader, to be clear, specific, and timely with communication?
An assistant principal is one of the school leaders, and in the crisis plan is one of 3 school leaders.
And in this context, at 1:40 in the afternoon, if you accept my representation, that that's when this conversation occurred, it was a 3, that there is still a 3 likelihood that there is a gun on campus. True?
Based on what you have asked me to assign to it, yes.
Okay. All right. And when we say a 3 likelihood, and you talked earlier about, I think you said you'd have to assess whether to search the person, the boy, or not, given his age and other surrounding circumstances. Do you recall that?
I don't know that I said assess, but I might have.
So, I told you earlier the last thing we talked about was over, under. Do you recall that?
Yes, I do.
And when we say over, we're talking about what's an overreaction to a gun on campus? What's an underreaction to a gun on campus? True?
Right. When I spoke about it in an overreaction, underreaction to a crisis event. But yes, we could specifically talk about to a gun on campus.
Well, that's what we're talking about in this case, aren't we?
I just want to be clear that when I spoke about it, I speak about it in general.
So what is an overreaction to a gun on campus at an elementary school? What's an overreaction?
Well, I think that when you want an example of it, you mean?
Yeah, I mean, you're saying you have to weigh the balancing test. What possibly could be an overreaction to a gun on campus?
So you want me to take it to the biggest overreaction I can think of?
Sure.
That would be when a student indicates that another child has something.
Yeah, but we're
Weapon.
talking about overreaction, underreaction in terms of responses, correct?
Are you asking me when it is already proven that there is a weapon on campus, or when there is a suspicion of a gun or a weapon on campus?
Which one applies here?
Which one applies to your questioning?
Which one applies to this case? A suspicion or proven? In your view,
There was a suspicion that the student had a weapon of some sort.
of a gun.
Students use the word gun, yes.
She used the word gun.
In her statement, yes.
So there's a suspicion of a gun. So let's use that circumstance.
Yeah.
There's a suspicion of a gun on campus. The assistant principal recognizes there's a suspicion of a gun, and for 2 hours, the foreseeability that the gun remains on campus is not zero. It's something more than zero. That's what we've just gone through. True?
Yes.
What's an overreaction in that context?
In a elementary school where there is the suspicion that a 6-year-old has something,
We're not talking about something. We're talking about a gun.
that a 6-year-old has a weapon that students
talking
have
about a gun.
categorized as a gun.
We're talking about a gun, man.
Do you want me?
What is an overreaction to a gun?
An example of an overreaction is that when a student says, student X has a gun, that we call a lockdown, we have an active shooter response, we search the kid, we put him down, we put him in cuffs, we drag him off until we can figure out that he had a Nerf gun or a squirt gun or a firearm.
So you agree that Ms. Zwerner wasn't expected to just drag the kid out of class, call a lockdown, and do all this stuff? That would be an overreaction.
An underreaction would be
Stay
to
with my
leave him
question.
in the student,
Stay with
in
my
class.
Stay with my question. You agree with that statement that I made, correct?
No, I do not. An overreaction, it would be an overreaction to tackle the student, get the police, yes, all based on somebody said he has a weapon or what small children call a gun.
So let's talk about underreactions. Underreaction is an assistant principal not calling 911. True?
Well, can I finish answering your previous question?
You didn't answer my previous question. You went on to your own question.
Well, no, I was trying to answer the question of you asked me about an overreaction, and then you brought up Ms. Zwerner as an